What's up? It is Saturday, January the 17th. Welcome to another Operation Wisedome. My name is Cameron James Wilson, and Operation Wisedome is powered by Power Inherent in the People. Hey, all of my Wisedomians, why don't y'all unmute and say hello, world, out there to everybody? And yeah,
Hello.
Hello,
What up?
hello, you two.
Morning,
Hello,
America.
everybody.
yeah, man. So we jamming on this Saturday. We got a really, really, really special guest today. Um, amazing. He is a fighter. He is a patriot. He is of sound mind. He is an upstanding, of moral character. I was able to meet him last year in person, him and his wife, and at the Sovereign Citizen event. And it was like, yo, man. He was like, yo, we're gonna work together. And I'm like, he's like, yeah, man. It's gonna be me and you, and yo, bro. And he just set the tone. And I knew from meeting him the first time that he was gonna be somebody that's really gonna get out here and get it.
Dropped off
He's,
shoes.
dude's never been in trouble before. I
No,
don't think he's ever had any issues whatsoever. Um, but man, these people treated him like he was, man, I don't know, his issue. But I want to welcome my boy that I love very dearly, Joe Ellis. Joe, say hello.
Thank you. Thank you. I appreciate it. Thanks for the kind words. And yeah, no, when I covered this before when I saw one of your YouTube videos a couple years ago. Um, I was like, yeah, that guy knows how to handle it. He recognizes God and where he stands upon his creator endowed rights. And I didn't think that we'd ever meet up, to be honest. I didn't. It didn't cross my mind. But then I saw you start up Operation Wisedome. Saw it on your channel. I joined. It's almost coming up on a year now. I think in February is when I first joined Operation Wisedome on Discord, and from there it's just been, you know, it's been such a knowledge dump and such a great experience. And then so anyway, before we get into that, I'd like to thank a couple people first. And first, I want to give all glory and honor to the Most High.
Mm.
Um, this
Tell it from your heart, bro. Tell it from your heart. 2025 was a crazy year, y'all. It really was the year of
it
the
was a
snake.
crazy year.
We were all shedding
Yeah.
everything that we needed to shed all across the board here in Wisedome. Go ahead, Joe.
Yeah. It was a very trying time.
Hmm.
Uh, I didn't think I was going to break down, but
Yeah, it's good, bro. Tell it like it is. Bring it from the heart. This is what we talk about in relation to irreparable harm.
yeah.
These are
Um,
things that go beyond the physical. It goes into the emotional, mental.
oh yeah, very
Uh,
trying.
yeah,
It was a very trying time, not just for me, but for my family, my extended family, and we leaned on God's provision more than anything else. More than any of the filed paperwork, the recommendations, the advice from friends and family. It was God was at the center of it, and uh, I'm thankful when it comes down to it. I'm thankful for the authority that's shared through us through Christ Jesus and the wonderful Counselor. It's I'm gonna get through this. I promise, guys.
no, you're good, bro. Tell it like you feel, man.
Um, there were definitely trying times, but then there was some really boost in lifting my spirit and confidence, and just knowing that I honor I honor God by recognizing, wow, this was this is harder than I thought. All right. So anyway, so I recognize um, and honor God by recognizing and honoring the inherent rights that are given to all of mankind,
Right.
not to trespass upon those created in the image of God, but to accept
Tell it, bro. We good, man. You good, bro. Tell it.
To accept God's invitation for us to participate
Mm,
in building up and strengthening our fellow man.
right.
First and foremost, by sharing the gospel of Christ and by teaching the way of Christ and the authority that we have over the darknesses of the kingdoms of this world. Man, that was hard to spit out. So I
It's all good.
apologize for the delay.
No, you're
Appreciate your
good, bro.
patience.
We all know how deep it is, and we feel that energy. That translates across the whole.
Yeah.
This thing ain't nothing, man. It's just you're right here in front of me. I can feel the energy.
And
And go ahead.
so I wanna thank Paul, the all of the pastors of the least out of Nairobi, Kenya, all the men in my Bible study group, friends and family that have prayed for us, supported us, lifted us up
Yep.
in prayer as we have gone through these trials. So I wanna thank you all. I also want to call out Kevin and Vicky. You guys mean a lot to us, to me and Aaron, Cam, all of Wisedome, James, Alira, Zeke for additional insight. You guys have helped me perfect my record, and you've helped me with learning court rules and procedures, and you guys have contributed to my overall success for this matter. And I just wanted to say that before we get into it. So I don't, sorry for breaking down. It's very emotional and and first of all, it's touching. The support that you guys have given to me and my family is it hits me to my core. So
I
so
mean,
Love
thank
you,
you
that's
all.
Joe.
the heart of Wisedome, man. What we give to people is that support and family. Because yeah, this is not an easy freaking ride to go through.
Yeah,
No,
everybody unmute and tell how much you love Joe. Love you, Joe.
No, we love you, brother.
Joe.
And you feel strongly about it because the world that we live in is wicked and evil
sure.
and selfish. And so to meet such a great group of people, such as this group, of course you're emotionally overwhelmed, brother. Guys don't get support like this.
Well, it's not just
Cameron
this.
created this
Well, it's not just
support,
this. It's not just the support though. Either man is
the
that
answers, everything.
victory. Yeah, the true victory dude got man.
Yeah. Yeah. So
Yeah.
I want to call out I have my mom that joined this meeting and
Oh,
my
awesome.
mother-in-law. So I see you, mom and Kathy. Welcome to
Miss Ella.
Wisedome. This is I
Welcome.
see them on the group. I saw Sylvia on earlier,
Mom.
but she must have jumped. But
That's
that's okay.
that's
Um, all right. So, okay, now that that's all over with and I'm ready to get into it, let me just lay some background onto how all of this started.
yeah.
And so, back in um, June, late June, my son he got pulled over with a traffic infraction, and he uh, didn't it was a traffic infraction. We all know we have the right to travel upon public roads and highways. He wasn't engaged in commerce, and so he I was helping him navigate through all of that, help him get his record in order and all of that. So his court appearance is on July 8th. He's got two folders, two binders of papers of paperwork to go through, and so I go up there, providing we have an inherent right. All of our rights are inherent, and they're only limited up until the point that you trespass upon another on someone else's rights. And so we have the right to assistance of counsel as protected and guaranteed in the Sixth Amendment of the Constitution, and also in your state constitution, and in this case, it happening in Virginia, Article 1, Section 8. And so everybody has the right to assistance of counsel. I want to make perfectly clear that the administrative courts are going to pervert that and distort it into representation by a licensed attorney at law. That is not what assistance of counsel is. Assistance of counsel, one, it doesn't represent somebody else. It's counsel. It's so whoever is being charged has to present themselves and answer to it, right? But you can still get counsel. Okay, the Holy Spirit is known as the wonderful counselor, and so parents counsel their children, and that's what I was doing. Elijah is my son, and so a father is counseling his and guiding his son. So assistance of counsel is a right that every man and woman gets to enjoy. Now, I was not up there representing him in any way. He was presenting himself, handling his matter, and I was there to actually provide administrative assistance because he had two folders, two binders, and juggling through it and helping him flip through folders and files and pointing out where filings are and everything else is assistance. So they wanted to distort that. July 8th, the judge was like, you can't represent it. So
Hold on. Well, let's hear a snippet.
okay, go ahead. Yeah, play it.
He is not a lawyer. He does not speak for me. I'm representing myself as a man, sui juris. If you'd let me state that I'm here making a special visitation and not making a general appearance, if you'd let me get into that, please, Your Honor, I'd greatly appreciate that.
And the person speaking right now, just to give a little context, is Joe's son. Okay. How old is Elijah, by the way?
He's 22 now.
22 out here speaking like this in the courtroom. Okay, with his pops right behind him, supporting him, making sure that he's getting the paperwork. And
yes, Your Honor.
If you want to address the court, approach the podium.
Your Honor,
People aren't allowed to speak from the gallery.
Okay, if it pleases you, Your Honor, I will step forward, but if let the record show that I'm still challenging jurisdiction, but I will step forward to the podium if it does please the court.
This man's not a lawyer. Have a seat in the gallery.
Your Honor, he is.
This is debatable. If you want to address the court, approach the podium, young man. And if he's not a licensed attorney
Your Honor,
to practice law in the Commonwealth of Virginia, he's not going to be allowed to address the court.
Your Honor, it is my Sixth Amendment right to have assistance of counsel with me here today. My Sixth Amendment right, pursuant to the Constitution for the United States of America.
Unauthorized practice of law in the state of Virginia.
What was that, Your Honor?
You want your friend to be charged with the unauthorized practice
Yeah,
of
so let's
law
pause
in
that.
the state of Virginia.
So now let me lay some background onto what it actually means to practice law in the state of Virginia. First of all, the statute that they pull up is.
You want to share?
Yeah, I'm gonna share my screen real quick and pull this up here. All right. Wow. Okay. So 54 dash. Give me just a moment. I'm gonna share it in a second.
No worries. You know how we be chilling.
Step out of the vehicle. I've asked you already 3 times. Oh.
Excuse me.
Which one's that? All right, we'll just do screen 2 and share sound. Okay. So, can you guys see my screen all right? You guys see my screen?
Yeah, we can see it.
LIS. Yep.
Okay. All right. So, any person who practices law without being authorized or licensed shall be guilty of a class 1 misdemeanor. Collection is blah, blah, blah. So anyway, so this statute actually doesn't list what it means to practice law. In order to do that, you have to go to the Supreme Court Rules of Virginia, and that's in Part 6, Section I, which then further takes you to the Virginia State Bar Association and their guidelines here for general definition. So even if you are charged with this, see, the warrant was defective from the very beginning because it didn't actually list any theory that the Commonwealth is alleging that I practice law. It just stated I violated 54.1-3904, doesn't list any of the elements, and we'll get into that. But the general definition here is, first and foremost, in order for you to actually be charged with practicing law, you have to represent to another by words or conduct that one is authorized to do any of the following. And
Uh-oh.
that's, yeah,
Got 'em.
exactly. Yeah, right from the beginning. If you watch the video of, if you listen to the hearing of Elijah's hearing on July 8th, one, me and Elijah over and over again, I'm not representing him. He's representing himself. It's stated by me, by Elijah. I'm there for assistance of counsel only, as protected by the Sixth Amendment and Article 1, Section 8, blah, blah, blah. But okay, so let's just say that you do represent to another, that you're authorized. Then you still have to take compensation, directly or indirect, to give advice or counsel. You have to select, draft, and complete legal documents. Now, what this means is not so much that you actually create the form. You actually have to sign it and put your autograph on it. Did I do that?
No, it's me.
You have to sign it and put it as if you're filing it for them. Okay. So like I can help edit documents, that's not, let them try to charge me with editing documents, So anyway, then represent to another that I can before a tribunal, which I didn't. I told the court I'm not addressing the court in any way. I'm here to provide assistance of counsel, and then negotiate legal rights or responsibilities. So none of those four. So the first threshold is this, did I represent to another that I'm authorized to do any of these four acts? And no, I didn't. So anyway, my point is that the warrant, let me pull that up. The warrant was defective, and it was so defective, it didn't provide any of the elements that stated any cause. All it did was just say you practice law. And then when I asked for the clarification, the discovery, none of that was answered all the way up until trial. It was still not answered, and we're going to get into that. So I won't bother pulling up the what do you call it? The warrant, but I will share this video. So this is the video of the trial. I have subtitles, and so I'll go ahead and play this. Let me minimize this here, and we can get
Wait.
Okay, yeah, all right.
Yeah, let's give here, stop sharing for a second. Let's give just a little bit more context, because some people really don't know what's going on with you, Joe. They don't know what happened. They don't know all the in-betweens. We still stuck right now in Elijah's hearing. That's where we at. We got to explain that a little bit more thoroughly. So
okay, all right,
yeah,
all right.
we
So
gotta give a little bit more context here. So what I wanted to do is come back over. I don't know if everything.
The only reason why I'm okay. So we're gonna in my trial, this video is played twice. So
okay.
So it's gonna get some context as we go through it, because allegedly the judge didn't hear this video until trial. So we are going to go through that twice.
Okay, well then let's get into. So there's a lot of details here, everybody. So what's going on is Joe, through this hearing, which I would love to kind of get through first. I don't know, at least a little bit to say, what happened. There were several elements that occurred before even coming to the trial.
I can clarify that. So yeah. Let me lay the background into actually where my arrest happened and all of that. So, so Elijah has his hearing on July 8th. The officer isn't there. The attorney isn't there, allegedly. Nobody's there. And this isn't the arraignment, which it is an arraignment, but the clerk and the judge both tell Elijah this isn't scheduled for trial today, and it's not an arraignment. But they didn't give him any notice other than.
Now, why do they do that?
Most likely because they're afraid of his filings that he's filed. He's filed.
What is the bigger one? What are they trying to gain from Elijah?
Well, they're trying to gain jurisdiction over him.
Thank you. Yeah.
Yeah, they're trying to gain jurisdiction over him. And he went in there. He was challenging it. He was asking for evidence of a verified claim supported by oath or affirmation. They issued a warrant for his arrest during the traffic citation, because of the statutes say that if you're going over 20 miles an hour, then it's a class 1 misdemeanor and cause for arrest. So they didn't have a warrant. They didn't have a verified claim. They're alleging he's engaged in commerce through the motor vehicle code. And so anyway, so July 8th comes. We have the whole issue. The judge has a problem with me standing by his side. Elijah doesn't cross over the bar. He's standing right behind it, challenging jurisdiction. And so, there's that goes on for, a few minutes. They place me in handcuffs, eventually take the handcuffs off of me because I go sit down at the bench in the gallery, and Elijah handles his business, at court. It gets scheduled for August 11th. So August 11th is his next hearing, where now it's set for trial. And so we get there August 11th by like around it was at like scheduled at 1 o'clock. We get there around noon because he was going to file some other notice. I forget what it was, but it doesn't matter. So we got there a little bit earlier. It turns out they issued a warrant for my arrest for allegedly practicing law at 11:02 a.m. So 2 hours before his hearing. Now, this is, in my opinion, this is a tactic to prevent me from actually being at court with Elijah because of what happened July 8th. So they don't want me there. And so they arrest me. They take me to the magistrate. I'm asking, when they arrest me, I ask to see the warrant, which they don't give me. They're like, you'll get it at the magistrate. And I said, no, you're required to provide the warrant upon arrest so that I can see and verify the elements. They don't do that. They take me to the magistrate. The magistrate, I'm asking these questions. Let me see a copy of the warrant. It says page 1 of 2. I'm like, well, where's the second page? It says I'm practicing law. And then that an investigator has made sworn statement. Well, let me see the sworn statements. I want to see what those sworn statements are include to see the validity of this warrant. It's totally vague because all it says is that I'm found in violation of a statutory code of 54.3904, unlicensed practice of law. Doesn't list any of the elements, and then it says I, Tyler T.J. Morgan, the investigator, blah blah blah. No, I'm sorry. It says I, the undersigned. This is the magistrate. This is Elizabeth, who's the magistrate. Says have found probable cause based on the sworn statements of T.J. Morgan, whatever. And I'm like, well, let me see the sworn statement so I can see and test the validity. And so anyway, I told her I'm reserving all of my rights. I'm not consenting to any jurisdiction. I want to see these things. Anyway, upon asking all of this, she's like, we're just going to deny bail. You're not answering my questions. She wanted my full name. I was like, oh, it's Joe Ellis. And she's like, well, your full name. I'm like, listen, before I give you any information, I want to see the full warrant. And she's like, you know what? You're going to jail. I'm like, okay. Well, just to let you know, I put Montgomery County Sheriff's Office on notice of liability for all of the trespass. So it's going to be a hefty bill after all of this. And so, and she's like, oh yeah, who's going to pay that? Well, anyway, these guys act as if they're untouchable. Anyway, those acting under the color of authority and under the color of law will be held accountable. I'll just
Straight
say
up.
that. That's it.
Straight up. Hey, let's give a little bit more just here in the first hearing real quick.
Are you aware of that?
Stop talking.
Are you?
Sir, are you refusing to have a seat?
I
don't want
am.
to hold you to contempt.
There's no disorder here for contempt to be
Well, you've
claimed.
been asked, you've been ordered by the court to have a seat.
I'm
Because you're
providing
not an attorney,
assistance
refusing
of
to have a seat.
counsel. I'm providing assistance of counsel. Are you denying this man's right to assistance
I am
of
not.
counsel?
The court politely inquired as to whether you
If-
were licensed to practice law in the Commonwealth of Virginia. Are you
Assistance-
licensed to practice law?
The Sixth Amendment allows, it protects the assistance of counsel, not a private licensed bar attorney, bar card holder, attorney at law.
It is private counsel. I am not speaking to the court. I am simply providing assistance to this man who is trying to exercise all of his rights.
Are you refusing to have a seat in the gallery?
I am providing assistance of counsel to this man who is exercising all of his rights.
The court has politely asked this gentleman to approach the podium because people aren't allowed to address the court from the gallery. We have chaos in here if people will talk to us from the gallery all the time. So, young man, come up to the podium.
Your Honor, if it pleases, again, I will absolutely come up to the podium. But I'd like to make it clear for the record that I am still challenging jurisdiction, and I'm not consenting.
What you want to argue once you come to the podium.
Okay.
The court's not going to listen to you when you're speaking.
Okay, but Your Honor, do you understand that I'm only behind here as to not consent to the jurisdiction of this court? But I will absolutely come up there and talk to you and address you respectfully, Your Honor. I'm trying to stand here in peace and honor. I'm not trying to disrespect anyone in this court. I'm just exercising my right and not consenting to the jurisdiction of this court until it has been fully established by a verified claim supported by oath or affirmation pursuant to the Fourth Amendment.
Of the Constitution of the United States. And I'm done with debating this with you. Either come up to the podium or you would be happy to.
I'll definitely come up. To my assistance of counsel.
Right, I'm going to ask you to stop speaking for a moment. You address your issue. Sir, I don't want to do something. I don't want you to force me to do something I don't want to do. So, will you...
Joe, it's your fault. You're going to force him.
Yep, obviously.
Yeah, you forced him to do what he did to you. That's how he believes.
I should apologize to him.
Sorry, Your Honor. We're just going to stand in our rights. Okay, so so you've already explaining everything. What happens is you do get detained in this hearing. Is that correct?
Yeah. Oh, yeah. Like I don't know, 3 minutes into it, I got handcuffs on me.
And this is the very first hearing, right?
This is the very first hearing.
And
yeah,
you never went to jail or anything, or was in contempt in relation to this first hearing. You were just placed in handcuffs, correct?
That's right. Yeah. Yeah.
And
he ordered the bailiff to what did he say? He ordered the bailiff to come over and place handcuffs on me. And that's when I asked her if she had a verified claim. There's no contempt. We're familiar with contempt charges now because of what they did to Elijah and Aaron from my hearing after they arrested me. But anyway, yeah, there's no misbehavior as to where it obstructs justice in the presence of the court. There was no judgment or anything disobeyed or anything like that. There's like 4 or 5 elements of contempt charges. None of them would have been met. So he did not really have any cause to hold me in contempt.
And now with this whole situation, from you and the family, essentially, the family as a unit coming in to support Elijah, how many people have gone to jail?
3. Me, Elijah, and Aaron.
And Aaron is
my wife.
Okay.
She was arrested at my arraignment after I was arrested, and I'll get into all of that.
Okay.
Oh, Aaron in here?
Yeah, I think Aaron is in here.
Oh yeah, I see Aaron. Okay, I see my daughter Haley too.
Yep.
What's up, Haley? I love you, and love you too, Aaron.
And so in this hearing, hold on. So in this hearing, there was also something that was very interesting where I forget where it was mentioned, but something had happened where the judge was offended at someone not standing up at a certain point in time, or
yeah. So that was okay. So before the audio recording, my daughter did not stand up when the judge entered the courtroom. Now, the background behind that is that these administrative law judges do not enter the courtroom with a Bible in their hand. And that was what originated standing up as the Holy Bible entered the courtroom, not the judge himself. That's obviously been distorted over the last 100 or so years. And so now it's more tradition. And so he took offense to that my daughter was sitting down. when he entered the courtroom. He gave a little speech before Elijah was called up, so we don't have that recording. But during the recording, he mentions it again, and he's like, "And I see what's going on here. Your whole little entourage. I see you smirking, lady. Blah blah blah." So he calls it out and just saying, and he takes it as being disrespectful to our system. He's like, not me personally, to our system. And it's like, well, listen, if your system is going to violate the rights of the people who are standing on them, and especially after you've been put on notice of the exercise and reservation of such rights, well, now who's more disrespectful? Is it the one actually trespassing upon those rights, or is it the one that's trespassing or violating some traditions of mankind that you have a problem with?
Yeah, and
So,
honestly, when I look at it, I see prejudice and bias just from those statements alone,
of course, yeah.
right? Because
Yeah.
no one can be forced to stand up as a viewer, first off, or even period. If they don't want to stand up,
Yeah.
they ain't got to stand up. You can't force them. It's not, we're not in a totalitarian state here to where you must stand, you know? So,
Exactly. Real quick, I see my son Josh on here also. Hey, Josh, sorry I missed you, buddy.
hey, Josh.
He's
He's like, hey, mention me, Dad. Okay, so we get through this hearing. Nobody gets arrested. This is Elijah's hearing, by the way. You were placed in handcuffs. There was a little bit of bias as far as statements are concerned coming from the judge in relation to your daughter not standing, but everybody gets to leave and everything's okay. So then we are coming into another hearing, are you just finding out randomly that you're getting arrested for a UPL? How does that happen?
So his next hearing is scheduled for August 11th. So we get there about noon. We go through
Who is we?
security. Me, my son, the whole entourage. With minus a few friends that couldn't make it at the time. But there's, I don't know. There's probably 8, maybe 9 of us.
Yeah.
So as we get through the security metal detector, they one of the officers comes up and starts to arrest me. You're placed under arrest. There's a warrant for your arrest. I'm like, well, let me see the warrant. And they're like, you'll get that at the magistrate. I'm like, well, you need to provide that now. And they didn't provide it to me while during the arrest, or the when I got it was at the magistrate, but it only lacked it was the first page and it was insufficient for listing the elements. Anyway, so that's August 11th. The warrant was issued at 11 a.m., 11:02 a.m., and his hearing was at 1 p.m. And so I see this as just a tactical move to prevent me from actually entering the courtroom with Elijah, more than anything else. And so, so I get arrested. I'm denied bail, and because I'm asking for all of the elements that they're required to provide, and they're not providing to at least show that it's a valid warrant, and so I get booked. I'm in jail. My hearing is August 12th. Aaron and my kids and some of their friends are waiting in the courtroom. So I'm in jail. They take me to another location, and I'm doing this Zoom meeting, or remote, trial type of hearing. So Aaron and them are in the courtroom and waiting for my hearing to come up. They're saying that it's basically nobody's in there. They don't have anything going on. And so Aaron's reading her Bible in the bench, on the bench in the gallery, waiting for my hearing to come up, and a deputy comes up to her and asks for her glasses. And so I'm not going to go into those details, but long story short, they hold her in contempt for misbehavior. Now, misbehavior, again, is one that obstructs the administration of justice in the presence of the court. There's no way that could be done when you're sitting quietly reading your Bible, waiting for a hearing to come up. There's actually no administration of justice going on at that time. So she's actually appealing. So they arrest my wife, and she spends. They gave her 10 days in contempt, and she served, like, with contempt, you serve half of that, on good behavior. I guess you'd have to actually do something severely wrong to do the full amount. So she's in jail for 6 days, and gets out, and then
this was for what? It's labeled as contempt, but what was
it's
the
labeled
actual...
as contempt, misbehavior, subsection A1.
And the
of
misbehavior
statute.
was what exactly?
The misbehavior, so the actual misbehavior was wearing glasses, recording capable glasses. So now that's in violation of the statute of, where is that statute? I got it up.
Now this is a public building, right?
This is a public building.
And it's open to the public to come watch any court hearings, correct?
That's right. That's right.
And so anything that you are eligible to watch, according to the Constitution, you should be able to record, correct?
Yes. Yeah. Yeah. I mean, it's public. It's public. It's a public court setting. And so, so statute 16.1-69.35:2, recording of proceedings in district courts. An audio recording of proceedings in a district court may be made by a party or his counsel. There's some limitations on juvenile and domestic relation district courts, where the court may impose restrictions. So, however, the judge of a juvenile or domestic relation district court may impose any restriction as necessary to comply with confidentiality requirements of such district court. That doesn't apply. This isn't juvenile or domestic relations. It's a standard. And now, because we're lawfully married, my wife is a party to the matter, and so therefore, their courthouse policy is in violation of state statute altogether. And so now, they do everything they can to just pull the wool over the people and expect them to just move on. So, so she had every lawful right to be there and to record the proceeding, for the audio recording, and because she was a party by extension of her lawful husband, who is pending arraignment for the unlawful arrest of his alleged UPL, which is now B. So, so at this point, on August 11th, I'm arrested on my warrant. Elijah is held in contempt after August 11th from his August 11th hearing. So he spends 10 days in jail. And then the next day, August 12th, I'm at my hearing, and it's the same judge who handled Elijah's matter. At this point, I don't know that Aaron is arrested because it happened like an hour before my case was called. So, I'm thinking Aaron and the crew are actually in there watching my hearing. So I see that it's the same judge that handled Elijah's. He obviously has prejudicial biases over people exercising their rights. Long story short, he ends up recusing himself. I told him he has to recuse himself, and then he first refused, and then eventually did, and told the clerk he's recusing himself, got up and walked out, and that was it. Then the next day, I have another hearing from a different judge out of a different district. What I don't know at this point in time is that the chief judge of the general district court at that court issued a recusal of the entire 27th judicial district to hear the case.
Now, wait. Did you say that all of the judges were recused?
All of them in 10 counties of the 27th judicial district in Virginia. So that's
bravo, bro. How do you get all of those judges recused?
It's not like I fought. It's not my filing or paperwork or anything else, but it was because Randall was the judge that first heard my arraignment on August 12th, and I called out his prejudicial biases. They're clear. You hear the video, man. I listened to the video again. It's been a while since I've listened to the July 8th hearing, and when I listened to it again last Friday at my trial, and man, you just hear his tone, his voice. He's got such a he's so disrespectful to people who are standing upon their rights. It's just anyway. So I called him out on it on the August 12th arraignment. I told him, hey.
This is the disqualification, right, of everybody?
Yeah, yeah. So what's interesting though, like this judge, Gino Williams, he's the chief judge of that county, that district court. I don't know how a general district chief judge can recuse all 27, the entire 27th judicial district of 10 counties. Like I get it if you can do it within your own court, but how additional 10 counties. So anyway, they actually had to bring in judges from outside of the 27th district to hear my case, and they ended up. I used two different judges, one for the August 13th hearing, which was like a reset of the August 12th that Randall had. So the August 13th one, that one kind of bombed. There, because I was telling them, look, I don't have there's no valid warrant. I'm challenging jurisdiction. They don't care. You're arrested. What are you going to do about it? And so, so at this point, when I call my wife's cell phone that night, August 12th, my son answers the phone and he says, "Hey, mom's arrested." I'm like, "Great. What is this?" She's my hands and feet on the outside, right? So, so that put a damper on my plans for a whole lot. And so now I'm trying to walk my kids through what they need to do to get me out of jail, to get a bond hearing and everything else. And they're basically intimidated by the retaliatory tactics that have been done, because at this point Elijah's in jail, my wife is in jail. They charged me with unlicensed practice of law. Nobody, I want to avoid any other family members getting arrested. And so they're like, yeah, we need to wait and basically wait for mom to get out. And so, and I get it. I don't want them to risk. I don't want to risk any more of my family in jail. They already had half of us in jail. And so, when Aaron finally gets out, on, I forget what day it is, but anyway, a week later, it's like 6 days. I think she actually gets out on the 17th. Then she's spending that whole week making arrangements to try to get an attorney to file a bond motion and get me released on bond. So that happens on the 26th, August 26th. We make arrangements with an attorney, which I'm thankful for, that we're actually out of here. I wanted to do it on my own, but I get it. The intimidation tactics on my family, nobody wants to. They were kind of like, we need to back off, which is just infuriates me even more, that that the government that's supposed to protect our rights is actually trampling all over them. And so, so anyway, she gets an attorney. I have my bond hearing. Okay, I have my bond hearing, and I'm released on a secured bond of $5,000. They pulled in another judge who was, they transported me to the courthouse, and then the judge was actually on a Zoom call. I don't know why I couldn't do another Zoom call, but whatever. And then I'm released on $5,000. We pay that, and then I'm home later that afternoon. And then it's get to work. But after I'm released, I needed like to decompress though. It was a lot of.
Now, did you paid a full bond?
Yeah, I did. Yeah, it was a $5,000 secured bond.
Okay, so you're getting all that back for sure.
I already did on the same day after trial when it was dismissed. I was like, all right, give me that bond check back.
Yeah, give me that. Okay, continue.
So I'm released, and like I it's so nice to hug family. So like,
now how many days were you in jail?
I was in jail for 16, I think.
It's a long time, bro.
Yeah. Oh, for sure. Yeah. It's a long time. It's such a waste of time. Like you're so limited to what you can do in jail. You're not like the people who can actually maneuver through the court system while in jail, well, first of all, they got a lot of time on their hands, so they can. But you're not moving fast. It's slow. It's a slow process because you got to do it by mail. You're not. It's not like you could just go and talk to somebody and everything is done for you. And you don't even have resources. You can write it up. Anyway.
Yeah, I remember speaking with you while you were in jail, bro, and it was just like, dude, this is the worst situation, and everybody's trying to figure everything out, and it's like, what's going on? What can we do? Where are we at? What options do we have next to friend filings? I mean, it was all over the place. And what was very interesting about it is how quickly his children were able to articulate or to facilitate. And I thought that was like, you've done a really good job with your children, bro.
Thank
Because
you.
yeah, they were there and they were ready and they were trying to figure out anything they possibly could to uh to get the situation fixed for Joe. And I was just like, man, this is really amazing. So you get out of jail, you're hugging your family, you're feeling the love again. You
Hmm.
understand how important it is
Yeah.
to have them every day. Go ahead.
Oh yeah. Yeah. No, I'm really proud of them. And
Go.
so I get out of jail and like I just need a week to decompress, spend time with family, and then it's, get to work and deal with all of this. And well, we have chickens and turkeys and we got animals. When half of us are locked up, there's some neglect. My kids, while we were gone, my kids and their friends really stepped up, and I'm thankful for them. Um, but we had like 25 eggs in the incubator, and so we got there's there were some things that needed to be dealt with before we can really even get to deal with these legal matters. And so anyway, Aaron and Elijah appeal. Elijah appeals his conviction in the general district court. Aaron and Elijah can appeal their contempt charges also, and and then I start to get to work on my filings. And document everything there. When I was in jail, you can get a write kit, a writing kit or whatever they call it, and so you get a pen. It's like just the little plastic pen, nothing that you can shank somebody with. It's just the little plastic ink thing, just garbage to try to write with this. But anyway, so I'm writing on all of my notes of what's going on during the hearings, the first one, the second one, and even the third one, and I'm making notes of what I want to tell them when I call them in the evening, what I want them, writing down what they tell me, what you, Cam, and Kevin are all kind of relaying back, and I'm taking notes. And I actually still have it. I have like 3 pages of notes during that 16-day period because I log each day. So you want to be diligent and start tracking everything from the moment that you interact with these agents acting under the color of law. You got to start your record from the beginning just because it's going to help you overall document everything. And so, where was I going with that? Documenting that, getting the case. Anyway, so I'm out of jail now, and I'm now starting to file my paperwork. I file a couple of notices. I'm sending notices to the magistrate for full production of evidence of the warrant, the sworn statements. That goes unignored. She doesn't answer. She and I know she's having nightmares. Same thing with Randall, and because they know what kind of mess they made, and I asked for. I reached out to the prosecution, asked for evidence. They gave me the two videos, two YouTube videos of the hearing, and then one of commentary that I made of the hearing. Um, that was recorded from Operation Wisedome. They were posted on there, and then body cam footage of one random officer while I'm already in handcuffs. When I asked for the body cam footage of the officer actually um, affecting the warrant, which they're like, we don't have to do that. It's I gave you all the evidence we're going to use. And then So I filed my notices for evidence. The attorney gave me some evidence, gave me 1 page of the warrant again, not the second page. It's like, look, you have full production of the evidence, provided. Um, if it says there's like even the incident report from the investigator starts at page 4, and so I get page 4 and 5. I don't get page 1, 2, or 3. Who knows if there's more pages?
Right.
And it's like, so. Anyway, and then the warrant, not the warrant, that incident report
But
is
wait,
all
let's pause there for just for a moment.
okay.
So if they're not going to provide you the first and second pages, what is that a violation of, and what kind of evidence is that?
Well, it's hearsay evidence, and it's a
There's another.
violation of
There's another.
authentication,
Okay, go ahead. Sorry.
and foundation of the evidence.
Could it also be exculpatory evidence?
Oh, absolutely, yeah, yeah. It could be exculpatory evidence as well, yeah. And in fact, it is. There are some exculpatory pieces of information in there where the report states, basically quoting us, Elijah said he doesn't represent him. Joe said he's not representing him. And it's like, well, damn it, how the hell can you practice law if you're not representing somebody?
Exactly. That's an element of the actual statute in and of itself.
Yeah,
The point
yeah,
is that people be like, again, they go outside of the statutes all the time. They're
all
just
the time.
going outside of them to try and match or just construe just a little bit the image that it could possibly fit. But when it gets down to it, that's why these statutes are written in such a way that is very specific to elements that must be met. And if those elements aren't met, it can't stand. It's unconstitutionally applied, y'all. All right, go ahead, Joe.
Exactly. All right. Hey, I see Elijah in here. Hey, Elijah. Hey, do me a favor, Elijah. Can you actually let the dogs in? Appreciate it.
Yeah, I got you.
All
That's
right.
awesome. That's awesome.
Okay. So, where are we? Well, where do you want to go from here?
I have to ask a question.
Go ahead,
Who
Bob.
let the dogs out?
That's right. I'm gonna release the dogs.
This guy. He's been waiting to say that for 20 years.
So where do you want to go from here? I can play the trial, or I can add some more background, but that's kind of really it. My filings are.
Well, wait. So we got Aaron's now out of jail. You're out of jail. You had to pay a $5,000 bond. That was cash straight to them bad boys. You're finally out. You're decompressing. You've gotten some information back from them, but not complete. And you're about to go back to another hearing. What is this hearing for? What kind of filings have you done? What have you done on the back end as far as like sending correspondence? Because it would be good, I think, to kind of show a little bit of the interaction that you've had, or even Elijah's had, directly with said prosecutors and or the state and or city or county and the court. Because what you've done is you've gone a little bit of a different approach. You've combined both common law and a little bit of statutory, and we see that even though you went more of a common law approach, you still went through the process, right?
Yeah.
And
Oh, yeah. It's gonna be. Yeah. Yeah. So let me just comment on that real quick. So, all of my language is geared towards the lawful standing and not the statutory.
show it
Okay. All right.
as you're speaking. Yeah, let's see just at least something so someone can see the differences between a little bit more of what's standard as far as maybe what a bar card attorney might file, right? Whatever the
Yeah.
case may be, the formatting versus something that Joe had approached and used in this particular situation. Which to say that did they always honor it and did they always respect it? No.
Nope.
But the fact still remains that a record has been made. And
Yes,
that
that's
record was in good faith. That is a very big deal when you know that you are building something to then therefore bring in later for a civil suit in relation to Title 18, Section 242 for the deprivation of rights under the color of law. All right, continue.
That's right. Yeah. Okay. So, one of the first filings I made was this notice and requirement for dismissal for legal insufficiency, just basically calling out the insufficiency of the warrant, standing upon my rights, the First Amendment, the Fourth Amendment, Sixth Amendment, Article 1, Section 8 of the Constitution of Virginia. This includes the grounds are based on the UPL rules, which I had to track down, and because the statute doesn't list the definition of practice of law, the statute doesn't even refer to
Zoom in.
the Supreme Court of the rules of the Supreme Court of Virginia. I had to find that myself, and then that furthermore links it to the Virginia State Bar Association.
Zoom in some.
Okay. And so this is just going over the rule definitions. You know, did I hold myself out as authorized? Holding out, no compensation, preparation, representation in court, record of confirmation. So Elijah filed this notice on July 2nd before his hearing. He filed a notice of private assistance of counsel and affirmation of exclusive voice, which expressly rejecting representation and retaining exclusive voice.
Good job.
No sworn rebuttal appears on the record, and this exhibit negates any insinuation that I represented Elijah.
Now, again, just for newcomers, people who don't know anything, why would you file something like this, and what purpose does it serve?
So Elijah filed this because he was assigned a court-appointed attorney, and he did not want it, and so this was a way for him to reject and rebut any court-appointed attorney, and so that he can litigate the matter himself. That was his whole purpose for this, and to retain exclusive voice over his matter.
And some would say, well, why not just file a motion rather than a notice?
So motions are instruments of the court that subjects you to their jurisdiction. Now, after going through this process, my feelings are mixed on this. Now, a notice is a lawful means to place. You have to place a man or woman on notice of whatever that notice is, and then they have an opportunity to respond and either accept or rebut or ignore it. If it goes ignored, it's going to stand as unrebutted and therefore tacit acquiescence, and will stand as true in a court of law.
Correct.
And so that's what the notice is for. The notice is still the method that I will use going forward in any matter, because that's gonna, once you actually get out of the administrative courts and into a lawful court, the notice and the rebuttal and the response to those are really gonna what's gonna help you perfect your record. And so it's a notice, and now you can do a notice in the form of a motion, right? Because I'm going to put the court on notice that I require a motion, and so the actual form for the General District Court says notice and motion for hearing. I don't know, something like that. I don't remember, but it starts with notice, so it's a note. Even they recognize notice for motion, something, whatever the form is. So notice is my go-to. Now, a motion, when it comes to people who say that a motion subjects you to the court's jurisdiction, that might be true, but in every single filing of mine, I make it clear that I, a man, Joseph Howard Ellis, and the reason why it's delineated, my name is in this context, stylization, for my Christian appellation is, one, it's camel case, not all caps. And now, yeah, there could be debate on whether all caps, blah, 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 is statutory name and all of that stuff. And there's some truth to there. But the camel case, with the hyphen, this is my given name, right? This is what my parents gave me. I don't pick that. And then this is my family name. This is what is handed down to all of us. So all of this, so the hyphen and the colon are just means of identifying that they're given to you, not that the man created them, that they were created by another man and woman, our mother and father who gives it to us. Anyway, that's kind of like a nuance, because they don't give a crap. When you get to the administrative courts, they don't care. They don't care about the lowercase I, or the name stylization, or that you're even in sui juris. To be honest, they don't. They're going to move forward and push this as far as they can up into the line where they possibly could, just to test your fortitude on how far you're going to take this.
Yep.
So the notice right here, I, a man, I claim that I'm a man, not a statutory instrument, not a resident, a thing to be identified, that I'm a that of mankind that creates government, Do give notice and require dismissal of the charge under the alleged charge alleged under VA code, blah, 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 in honor and peace for the following reasons. So all of my notices are clarifying I'm a man, not some statutory instrument or tool. I expressly reserve all creator endowed unalienable rights. Nothing herein constitutes consent to jurisdiction, joinder, corporate agency, or waiver of any right, remedy, or defense, whether at law or in equity. All objections previously made are preserved. So every single one of my filings have some similar language to this that states, that clarifies my status, invokes all of my rights, waiving none, and challenging jurisdiction to some commercial or corporate joinder or agency or any other type of instrument that puts you subject to any kind of rules, ordinances, codes, or anything else that is below the lawful supreme law of the land. Okay. So this is like 26 pages. So this is the order that goes with that dismissal. They ignored that. What's this one? This is the memorandum of law.
And did you say, when you say they ignored it, did you get any kind of written determinations? Did you get any?
I didn't get it
from the prosecutor?
So with this filing right here, I filed it's the notice for dismissal, compelling the prosecution for production of evidence, a bond modification to lift the travel restriction. Yeah, for my original bond included a $5,000 secured bond, and I can't leave the Commonwealth of Virginia, which was just excessive and unnecessary, because my domicile is Florida, and
Okay.
so.
And just real quickly, for anybody who's just joined here recently, what we're doing is we're going through Joe's situation. Joe was charged with an unauthorized practice of law. He was arrested, held in jail for 16 days. Other family members were arrested just for being present and also standing on their constitutional rights to record anything that is in public. And right now he's out of jail. We're speaking on where we're at in the timeline. And now he's making filings and we're going through all that. So I just wanted to update for anybody who's coming in just a little bit late. Go ahead, Joe.
All right. So my initial filings was the dismissal for insufficiency of the warrant, the bond modification, the audio recording, and I think judicial notice. I think the judicial notice was, I filed that at the hearing. So let me just go through this real quick. I'm going to skim through it. So this is the memorandum of law. That is again asserting all of my rights. It's in support. It's why the dismissal should be supported, and it's essentially that the Commonwealth hasn't provided any theory of practice of law, the controlling standards, and I refer to them through the Virginia State Bars Association. The constitutional ceiling showing that the conversion of our right into one of licensure is repugnant to the Constitution and void ab initio.
Void ab initio.
So that's why I pulled in Marbury versus Madison, where rights are secured by the Constitution are involved. There can be no rulemaking or legislation that would abrogate them, and that's what. I'm sorry, that's Miranda v. Arizona, where where a law like that is void from the beginning.
Yep.
For Marbury versus Madison, and that's what they're trying to do. The statutes are trying to convert our rights, at least this statute anyway, are trying to convert our right to assistance of counsel into one that requires licensure, which is absurd and it's repugnant. And the judge says that. At my trial, says that we have an egregious, Elijah and I, that we have an egregious, absurd view of the Sixth Amendment, something like that. And it's like, yeah, I don't think so, guy. It's egregious to try to convert your right into a license.
Right.
Okay. And then First Amendment, as first of all, nobody's going to tell me who I can and can't speak with about their rights.
Right.
So that's why I called in the First Amendment. I also pulled in some case law that allows the distinction between practice of law, where you can, like, there's Johnson v. Avery, um, is a case where courts, somebody was arrested and was, is that the right case? I can't remember. I think this is the one where somebody was arrested and is actually getting help from other inmates, and then they want to charge those inmates with UPL, and they beat it. So
Good.
it's ridiculous. The whole charge was ridiculous. It was just a retaliatory effect to try to hinder my access to help Elijah and effectively hinder Elijah's access to assistance of counsel for his matter. And then I list some arguments about the no element is met, and they ignored this. They completely ignored this. I filed this before my hearing. My motions hearing was scheduled in November 6th, I think it was. So I filed this well in advance. They they heard this at court, but didn't issue any written determination. And then when after we left and they denied it, and I asked the clerk for the judge to provide a written determination, the judge responded to the clerk, who relayed that to me, that said that I'm not entitled to a written determination because it was addressed at open court.
Oh God.
Yeah. Okay, fine. That's fine. If we are, I get it. We're in a court not of record, so you obviously have no record of that that it was addressed at open court. But whatever, we'll deal with it. So that's why I filed an amended motion to dismiss, and this time, the next time was with a motion for bill of particulars, again, which they denied in writing this time. But anyway, so let me just skim through this, because this memorandum of law is just long and not necessarily. I also, part of the memorandum of law, I included a copy of Elijah's notice of private assistance and exclusive voice, so they had a copy of it.
Good call.
Yeah, and but they ignored it. So this is actually a copy of Elijah's notice. Let me zoom out a little bit here. So this Elijah Lee Ellis, a man without corporate status or contractual obligations, the statutory bar administrative rules of representation, hereby provides this lawful notice that I retain and act under my creator endowed unalienable right to receive private assistance of counsel of my choosing. I do not consent to representation. Any man or woman assisting me in a private capacity shall not be acting as an attorney nor speaking for me, but rather offering assistance.
Perfect.
Now, this investigator, he might want to find a different job. I don't know. But if you actually listen to the audio, if you actually, investigated the court record for Elijah, you'd see there's no way that we can actually claim Joe was practicing law. But
Right.
whatever.
Yep.
Even by conduct.
Right.
This is what it says, 210.
All right. Hey, April.
Go ahead, Jim.
All right, so that's that. This is the rules of the Supreme Court that basically takes you to the VSB.org website, where you find this. So I've included this as part of the memorandum of law that supports it. They've ignored all of this, and I think that's just the rest of this page.
Memorandum.
Yeah, the memorandum law. Okay, so that's that one. This is the notice of evidence for the court. I'm asking the Commonwealth to provide all evidence and answers to questions. And I should have split this up, because of the production of evidence, the judge was like, well, the Commonwealth gave you evidence already, so we're going to ignore this, and they're not going to have to answer any questions. This is what I really wanted out of it. This is why I split it up into the bill of particulars. And so
now, just quickly, something that's very interesting that I just released to all Wisedome members, exclusive donating Wisedome members. was something that Chris Beatty brought forth in relation to a motion to dismiss and then your bill of particulars. And actually just how powerful that bill of particulars is. Because again, when you're getting precise on the requirements as far as elements and things that are required for them to provide to you, right, on their rules, it gets crazy. It gets to the point where they don't even want to move forward because they can't answer all the requirements that they are required to answer, right? Or let's just say something is filed as far as a bill of particulars and then they don't answer. Well, that's a malicious prosecution. You're not playing by the rules here. You're failing to prosecute at that. And we've seen dismissals just come off of things just like that. But the bill of particulars is very powerful. It's been around for a long time. Some states still clearly don't or don't allow it. They've moved it or tried to move it into a motion for more definite statements, which is very similar. But yeah, when you get into these bill of particulars, man, it can be more powerful than a motion to dismiss in some cases. And we went into that in great detail here recently. Go ahead, Joe.
All right. So those questions include questions for the sheriff, because they're the one that executed the warrant. I also have questions for the magistrate because she's the one that actually issued the warrant. And then I had questions for the Commonwealth right here that they didn't go for. So they didn't answer. The judge was like, yeah, you got all of that in your evidence, your discovery, which isn't the case at all. So that was that one. And then these motions right here. So these notices, so I filed this on, I forget what day it was, but it was before the hearing. I ended up, October 27th, I scheduled a motion and notice of hearing is their form. Now, I was going to use my own form, my own notice, but they had this online, and I was like, all right, fine, I'll do that. So, and what it does is require for the following reasons, the hearing on these matters before further proceedings occur, notice and requirement for audio recording, dismissal for legal insufficiency, written determination of probable cause, production of evidence, and lift travel ban restrictions. And this is just the cover page for all of that. So the this one, notice and requirement for written determination is 51 pages, but that only includes like some correspondence and evidence. Yeah. This is the notice and requirement to make audio recording. And now, the only reason why I ended up doing a notice for it is so that these jerks at the security scanner doesn't prevent me, like they did last time when Elijah went there on his August 11th hearing. Because they're like, you don't have written authorization. I'm like, you don't have to have a damn written authorization because the statute here, your policy, your courthouse policy is in violation of the state statute. So anyway, so an audio recording of proceedings in a district court may be made by a party or counsel. It says nothing about requiring permission. And it chaps my ass that they keep trying to push that BS.
Facts.
So, so I call in higher law and due process, the method, bringing in a quiet audio recorder to place a counsel. And actually, so this is my audio recording here. This is what I ended up doing. I got this little tripod right here, and I got this little audio recording device. And so I put it in this little clip, basically set it right in front of the judge's bench, on the little ledge, and so it picks up audio from both sides. It picks it up pretty well. I mean, it's not the best, but for what you have to work with, I think I paid, I don't remember, maybe $60 for it. It worked well, and they couldn't prevent me from doing it. Now, in circuit court, they're gonna probably deny that because that is a court of record, and they have a court transcriber, just a court reporter, and then you pay for that. So you most likely won't do, which I'm thankful it didn't get to the point of having to go to appeal it to circuit court, and that it's over with. But if they did, my record is perfected, and they would have had some answering to do why they ignored all of my filings.
Right.
Okay. So order, they actually they didn't execute this order. They provided another order, and that order was the defendant and the Commonwealth can bring in a recording device.
So then let me ask you this. Why was Aaron arrested?
Aaron was arrested for the alleged charge of misbehavior. And that misbehavior charge has on the order, the contempt order, wearing wearing glasses or recording capable glasses, something along those lines. And okay, well now that is in a violation of 16.1, 69.35:2. So
That's crazy. So you see
I know.
how they violating their own rules within their own establishment.
Yep. Yeah. The courthouse policy is in violation of state statute.
Insane.
Yeah. So anyway, so they executed that. They granted this order for audio recording, and provided that. They deny. Oh, they also granted. This is my notice to lift. This is the bond modification notice and requirement to lift travel restriction and to amend conditions of release. Basically, I'm telling them I'm not a flight risk. I have no criminal convictions. There's no man or woman coming forward to press a claim and everything else. And so, if they're not going to provide it, they need to provide. I require the court to provide a written determination for keeping the travel restriction in place. So they're like, now, okay, granted. So I was able to travel whenever they execute that. I think
Right.
whenever it was.
Yeah.
They didn't actually they did fill out this order. They used this order and executed that one and sent me the copy. And then they've ignored this written determination for probable cause. They're like, this is cumulative of the evidence that you received, which is not the case. We still don't know what the probable cause is, other than they claim that I violated a statute. They don't list the elements of that statute. So let me move on here. I provide some exhibits, communication. I tried to reach out, in good faith. We have email communication. That's why this thing is 60 pages total. This last one is all. I try to make it easy for them too. Here, fill out this form. Here's a timeline. Does it exist? Does it not exist? They're like, we're not doing all that extra work. Denied.
And let me ask you something too. This is very interesting. Have you ever seen this before or used this before, or is this of your own creation?
This is my own creation. Yeah.
See how this works, y'all? You have to understand that you truly are in power. Once you understand the rules and kind of the regulations, you start saying, oh, well, if they're required to do that, or if I want to operate in good faith, I am going to create that and provide that for them. That's the whole point of this. You don't have to follow the same traditional route as others in the private common law way, or in the same manner that they do, being on the private side. It's more common law side. Like, I know who I am. Therefore, I'm going to utilize all of my authority to bring forth notices, claims, and all of this of my own volition in operating in good faith. And that's what I think is really important here. You should zoom in a little bit, just a little bit. You don't have to fully full screen it, but just a little bit. And I think that's what's important, because you can clearly tell that this is of his own creation, right? And whether they answer it or not, you're still operating in good faith. And it's easily able, again, to bring into any civil matters moving forward, federal civil matters. Go ahead.
Yeah. So now I have some exhibits on communication with the Commonwealth attorney, along with, I tried to resolve the production of evidence issue. This was directly to the attorney, asking for the specifics. And she basically said, well, we gave you everything as required under the rules of evidence. which I provided a copy. This is the copy of the warrant. No, I didn't redact that. That's fine. But here, this warrant.
You can turn it, Joe.
Yeah, I know. I'll do that. I think it's going to do it for the whole pages.
No, I should do it just for that one.
All right. Ignore my social security number. I don't care. It's on here. I'm not going to really try to use that. But anyway, the practice of law not being licensed or authorized, and then here, I, the undersigned, have found probable cause to believe that the accused committed the offense charge based on sworn statements. Well, show me those sworn statements.
Yeah, where are they?
Yeah. Anyway, I brought that up at court, and the judge is like, I actually have that hearing recorded, and the judge is like, well, that's the sworn statement is really meant for people who aren't government officials, so that they don't. Yeah, and I'm thinking, yeah, no, this is actually, these rules are in place so that there's no government overreach, but okay. So this report, he was referred a case. He was informed that, so no firsthand knowledge whatsoever. But he didn't even get called to the witness stand. The Commonwealth decided not to call him. I didn't want to call him, and so I didn't interview. I didn't cross-examine Tyler Morgan.
Man, I wish we would have heard that.
Well, the only reason is because if the Commonwealth wasn't going to do it, being in the General District Court, not of record for this matter, I don't care. He's going to get interviewed later on.
Deposition's finna be real nice.
So, yeah, where is it? There's in here, it says the judge anyway, somewhere in here, it's like line 18 or 19. Elijah replied and said the mail was private assistance that would be assisting him. No, that's not it. Elijah stated, anyway, somewhere in here, it's specifically that he was 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 18, 19. Said the mail was his private assistance of counsel. The judge informed him that people aren't allowed to speak from the gallery, and if he wanted to address the court, he'd need to come to the podium. Elijah replied and stated that he would step forward, but wanted the record to reflect he was still challenging jurisdiction. So, anyway.
So it seems like he was just listening actually to a recording and maybe had possibly never spoken directly, or at least that's what he's implying through this report, that he had never directly spoken with the judge.
Yeah. So he says that he knows. So Tyler was referred a case by the Commonwealth's Attorney Office.
Okay.
Okay. So not sure who this, actually, I do know who this is because it's right here. So Seabone Stanley, that was
name.
the attorney for, this is Caroline. This is the attorney who handled Elijah's case on August 11th, or at least was the prosecuting attorney for it. And then where else was it? So that's where it all originated from. So
interesting.
She allegedly wasn't even there at court, so I don't know where she got that information.
Everybody's talking. Everybody's talking.
Everybody's talking.
Yep.
And so anyway, so that's where Tyler gets his information, secondhand information, and then he does review the video, and then he also speaks to Deputy Simpkins, to Angela, about what happened that day. But he doesn't speak to her until the actual date of my arrest. And then this isn't even filed until a day later. Anyway, what else? This is more evidence of my communication with them, with the sheriff's office. With I asked for the sheriff just outright denied. They're like, well, this isn't under investigation, and you are using a PO box, not a mailing address, so we don't have to give you anything. And this is a FOIA request. And I'm like, it's not a FOIA request, Mark. Mark is wrong here, and he's gonna have to answer for that. He's the custodian of record for the sheriff's office. Brandon, on the one hand, said, yeah, I'll get you the information while Mark is gone. And then Mark comes back and he's like, nah, And I'm like, well, yeah, you better. It's not a FOIA request. This is a notice for evidence. And so anyway, so I provide all of that, and they don't give a crap about any of it. They didn't look. I'd be surprised if the Commonwealth or the judge even looked at it, to be honest. And so sometimes you feel like your paperwork doesn't do anything, and maybe it doesn't for that court, but it's for your record. So
Yep.
the only reason why you're doing all of this is to perfect your record.
Yep. You're showing good faith while they're showing bad faith. You're showing that you know the rules, you know what you can request, and that they're not providing them. It's bad faith all the way throughout.
Yeah.
They have to know the rules, man.
Yeah. And then at my motions hearing on November 6th, I filed a notice for judicial law. And this was to put the court on notice, officially put them on notice, that they need to recognize all of the supreme law of the land, the constitutions and the articles and amendments that I'm invoking and requiring protection under, along with the statutes and rules that they need to follow. These VA codes, this is recognition of common law. And actually, let me just pull this up real quick because it's pretty good.
Hey, Joe, you see my message on the chat?
No.
Directly to you? Just wanted to have you see that real quick.
No, I don't. Direct to me? No. Okay, let me see. I see that. Okay.
Okay.
All right, no problem. Yeah, you want to set me as a host, I can take care of that.
Okay.
All right. So what is that? 1-200. This is the reason why I'm pulling this up is because everybody, should be looking at this themselves as well. So this is a statute that recognizes common law. So the common law of England, insofar as not repugnant to the principles of the Bill of Rights and the Constitution of this Commonwealth, shall continue in full force within the same and be the rule of decision except as altered by the General Assembly. So there's a statute that recognizes common law. The other one, so I'm sure there's going to be something like that for other states as well. Let me pull this up. What was that? 248. 248. The supremacy of federal and state law, the constitutions and laws of the United States of the Commonwealth shall be supreme. Any ordinance, resolution, bylaw, rule, regulation, or order of any governing body or incorporation, board, or number of persons shall not be inconsistent with the Constitution and laws of the United States or the Commonwealth.
It's a mic drop, bro.
It's a mic slam.
Yeah.
This thing.
Add on to that.
What's that?
Go ahead.
Can I add on to that? I learned from Tanawha that every state constitution puts themselves into subject to the federal constitution.
Correct.
I can see. I yield.
Thanks.
Yeah. So their own statutes that they're relying on in these administrative courts calls out the recognition of common law and the supremacy of the Constitution.
Yeah.
And so that's what this notice of the notice and requirement for judicial notice of law is doing. And I'm pulling that in along with the authorities to take judicial law, this statute. Okay. So if they want to ignore the judicial notice of law, you are bound by it, by this statute. You got to point it out to them just because, well, whatever. I won't be disrespectful. And then the Supreme, the rules of the Supreme Court, the rules if they want to rely on that. So I'm pulling everything in. Here's the rules of the Supreme Court of Virginia on why you need to take judicial notice. Here's the Virginia state statutes on why you need to take judicial notice. Here are the rules of the unlicensed practice of law and the Virginia State Bar Association that the rules of the Supreme Court want to delegate to. And then the cases Brady v. Maryland, Giglio v. United States, Johnson v. Avery. So these cases are I've cited in my notices and filings. And so I'm just including all of these into one official judicial notice of law. Again, whether this was actually used to my benefit for the judge to actually make his final decision or not is really up in the air still, just because he did move to trial under my objections without any theory, without the Commonwealth providing any theory beforehand of what the charges are, of what the elements, what the essential elements of the charges are. The charge was obviously that violation, that code violation of practice.
And let me ask you this: had you requested an evidentiary hearing?
I did, and I did that at the motions hearing, and he's like, "We're not going to do that." He didn't provide any reasoning for it, or maybe he said that the evidence from discovery was sufficient, which I rebutted. I was like, "It's not sufficient, otherwise I wouldn't be asking for it still." But he denied an evidentiary hearing. Yeah. So, and again, when it comes to these administrative law judges in these lower courts, these general district courts, not of record, I don't want to say it's free reign, but they're going to push it. They're going to push the envelope to try to get away with as much as they can up until the point that they can. So you better be prepared. You know, if going into any court matter thinking 1 or 2 hearings is going to be all you need, that's not the case. I think that's wishful thinking.
Well, that's what's been pushed. That's what's been pushed by all these people that, want to say it's just a silver bullet. I got the document that's a silver bullet, and it's like, nah, man, you got to know who you are. Again, know the process and go through the procedures.
Yeah. And so, I have all of these with these sections, the brief and legal bridge, why these authorities matter, the required order taking judicial notice, the constitutions, the authorities, Virginia law, case and rules, official publications, and then along with the exhibits, I provide a copy of the relevant parts of it. Actually, I think I might have referenced some of it by reference only, rather than providing copies. Anyway, doesn't matter.
Yeah.
But this one's like 48 pages. And then there's the order for judicial notice. Now, this was unnecessary, but I wanted to do it just because I felt like if they have an order, it is a notice and requirement. Now, a notice is just a notice, but I want them to actually act on it, because Elijah filed a notice of the audio recording, but they denied that immediately because the judge didn't do anything with it. If he saw it, he's just ignoring it. But if it has an order, then they're likely to either deny it or grant it. He didn't do anything with this. He didn't deny or grant it, but they're on notice. And I don't care if they do anything with this order. This was really just a recognition that the court is going to recognize the judicial notice.
Correct.
So don't expect them to rule on any order for judicial notice.
And that's a great mention in the chat. Thanks, Thomas. Thomas says in the chat, attorneys are not even producing documents like this. And that is correct. They're not even getting anywhere close. That's the point that I think Wisedome is trying to bring forth as a collective group of individuals that's coming together to make this mastermind, is that we're in the age of enlightenment to where you can be better than what a public defender or a paid attorney might even do. It's like we've seen it time after time now where, like in Hayden's situation, paid $5,000 to a lawyer. The lawyer's literally doing nothing, saying that he's worked 80 hours but has produced nothing, while Hayden's over here working 10 to 20 hours and has produced everything to completely get his case dismissed all on his own. The power's with the people. You got to retain that power, but it comes again from getting the knowledge, wisdom, and education. So, all right, move forward.
Yep. And so these are all just exhibits for the laws that they need to follow. And then this last filing right here, pulling that up, this is the last thing I filed. This was December 15th on my birthday. So I spent a couple of, I can't tell you, I don't even know how many hours I put into all of this, but it's a lot. Anyway, so this one, notice and requirement for motions hearing, the amended motion to dismiss, and the motion for bill of particulars. Now, this one I use the language of motions to dismiss and motion for bill of particulars. just because I felt like the rest of my filings are well established, that they're notices, and then now we can just address these directly. So
Yeah.
this one was
So essentially, you're saying, well, I've been addressing these people in my common law form, right? Not really getting much response. Now let's see if I put some of their own type of paperwork on them and see what we can get, right?
yeah,
Yeah.
yeah,
Okay.
yeah. And so they denied this. The judge denied this, said that it was cumulative to the previous dismissal. Um, And now this one was nice and short. It was 4 pages. It calls out the defects on the warrant. Doesn't list any of the essential elements as required. And then the conclusions: for the foregoing reasons, the accused respectfully moves the court to grant the motion and dismiss the warrant and charge. And they're like, yeah, that's didn't happen, which should have though.
Right.
This is the bill of particulars. So this one is the points of authority and the reason why I'm requiring it. This statute identifies that you can bring it up before trial, which I did. So, but he denied this before. He denied this like 4 days after I filed, and then I still renewed the motion at trial, which is well within my rights, and they need to recognize it under the statute.
Good job.
So the defects on the warrant just calls it out. It only states a
Zoom in
conclusion
a
of
little bit.
law.
There you go.
In this matter, the warrant alleges only the accused within the city limits, on or about, did lawfully violate this code, and recites the magistrate found probable cause based on sworn statements. The warrant does not identify the specific case, the courtroom, or proceeding. It doesn't list any of the essential elements that's specific, because the warrant, if you look at if you look at the Fourth Amendment, it needs to list the specifics of the warrant for it to issue to be valid. It does not name any person he's alleged to have represented, doesn't describe any words or acts or omissions that supposedly constitute practice of law, and doesn't specify which theory of practice of law the Commonwealth relies on. And then I go into what those theories are, which I feel like I've done a couple times on this call, so I'll just skim right through this. The conclusion, because of that, needs to be the court needs to compel the Commonwealth to provide the bill of particulars, which he denied. I think I have that denial in here. May not be in this one, but basically, let me see that order real quick. He states that. Is this the one? Nope. This one is actually my dismissal. This one he denies. It's denied. See attached, incorporated and made part thereof. And he states that the grounds for dismissal set forth in the defendant's amended motion to dismiss and vagueness are cumulative of issues previously raised by the defendant. It's not cumulative. It's actually specific elements that are different. While they may be similar, it calls them out separately and specifically. Previously raised, and therefore the defendant's motion to dismiss is denied. So he's denying it, just doesn't want to address the defects in there. And then the court finds the defendant's bill of particulars seeks excessive discovery beyond which the Commonwealth is required to provide, which it doesn't. This is an outright lie. Whether he believes that or not, I don't know, but this is not true at all, because the bill of particulars is specific to the defects in the warrant and the charge being alleged, that it needs to list the theory that the Commonwealth is alleging. And the only thing that I received in the discovery are videos, the warrant, 1 page, and the incident report. None of that lists
That's
the damn
common.
theory.
And that's common. The bill of particulars is to get extensive and more detailed information. So for him to say that it's extensive, that's crazy, because that's the whole point of the bill of particulars, is to give more information beyond what the discovery is providing in and of itself. It's ludicrous.
Yeah. But I would need this. I think this is too strong of a word, because the bill of particulars seeks specific answers what the theory is, not anything. It doesn't list anything extensive. You have 5 questions to answer. That's it. 5. Answered them. So, and he ignored it. He's like, yeah, it doesn't. So anyway, that's so those are all my filings. Those are all my filings. The only ones that actually were granted was the audio recording, which again, I shouldn't even have to get an order for that because of the statute that says a party can record in a court not of record, and the bond modification to lift the travel ban. So those are the only 2 orders that were granted that I filed. Everything else was ignored, and that's that. So the hearing now, I don't know if you guys, the hearing, the actual trial is an hour and 38 minutes, and we're 2 hours into this. Is it 2 hours?
I
2
love
hours
it.
into this call, and
Yeah,
we haven't even touched this. So
yep, I love it.
Should I play it?
Yeah, bro. What are you talking about? Let's go.
All right. So this is I'll try to
Wait,
skip through.
1 second.
All right. So this is the recording of the trial, and I got some subtitles. I'll try to skip through some blank spots, but there aren't too many. And you guys see the subtitles okay? Do I need to
lower the volume a little bit. Keep going.
Make sure it's muted.
Is that better?
Hold on. Yeah, 16 days in jail.
You were charged with practicing law without being authorized or licensed, and had you pleaded that to say you're guilty or not guilty or no contest?
I'm sorry, I didn't hear that last part.
Pleading guilty or not guilty or no contest?
I'm not entering a plea at this moment. I'm here visiting specially to settle controversy without waiving any rights. And I require the record to reflect that I object to any reliance on assumptions in place of evidence, and renew my motion for dismissal and release the bill of particulars. I believe the court erred on the last 2 denials, and moving forward with a vague warrant or no bill of particulars prejudices the accused of any proper defense.
I overrule your motions. I'm going to put you down for not guilty plea.
All right, note my objection for that, and I'd like to ask the court, since it believes that the warrant is sufficient and specifies the essential elements required for the charges, to state where on the warrant that it is sufficient. It only makes a conclusion of rather than list any of the elements. It states an alleged violation of a code of practice of law without being authorized, but it doesn't list any specifics related to the name, the act, or any theory which the Commonwealth is proceeding.
It does not need to do that. So overrule your objection. Note your objection, but overrule it.
Okay.
All right, you can have a seat.
I'm sorry?
The warrant doesn't need to list those elements. That's crazy.
Seat.
Okay. Where would I have a seat?
Ms. Petty, good afternoon.
Good afternoon, Judge.
I'm all ready to present the case.
Yes, Your Honor. I have one question before we begin. I noticed that the defendant set some things up there. I assume that's some sort of recording device, and but I want to clarify what that is, please.
That is a recording device.
To make an audio recording?
It's an audio recording device.
Only?
That's correct.
The judge, the normal practice in this court would be that if it was recorded and then reduced to some other means of writing or something else, or was going to be used, that a copy of that would be provided to Commonwealth. So I certainly have no objection to it being recorded, but would just ask if we proceed further that a copy of that be provided.
Is that a problem?
Well, before I answer that, I would still like to address the bill of particulars. So, because the Commonwealth hasn't provided what they're alleging the accused is being charged with, listing the elements for that. So, I think that before I answer that, I'd like to know for certain what the theory of unlicensed practice of law that the Commonwealth is alleging.
Again, I've made my ruling on that. We're not going to go back and revisit it. And I guess what Ms. Pettit is saying is that if this is going to be transcribed or anything at some point, that the Commonwealth will be provided with a copy of the transcript.
Yeah, I mean, I believe that's going to be optional for me to do, and the Commonwealth hasn't been really cooperative with listing the essential elements. I don't think that I'd be willing to do that. I might be. I mean, I don't really have a problem doing that, but there needs to be some kind of give and take here that I don't see is being given. There's no theory under the rules of practicing law that's been stated on the record. So moving forward without those being addressed highly prejudices the accused to provide a proper defense.
Okay.
So,
Ms. Pettit, let's just leave it that I don't know the circumstances under which it may come to pass that it would be transcribed, but if it is, and then if there would be a subsequent proceeding, that you could just request that at that point.
Thank you, Judge. Commonwealth's ready.
Okay, you want to call your first witness?
Deputy Simpkins.
Swear affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
Mr. Ellis, the Commonwealth has called a witness. When the witness is finished testifying, if you have questions, you may cross-examine the witness. Go ahead.
And Judge, I would make a motion that if there are other witnesses in the courtroom, that they be separated at this point in time, please.
All right. Do you have any other witnesses to call?
Perhaps, Judge. I may call Elijah Ellis.
I object to that, Your Honor.
On what grounds?
On the grounds that there's been no subpoena, no notification.
Doesn't need to be.
I'm sorry?
Does not need to be. If he's here, he's subject to being called as a witness.
Well, no, my continued objection.
All right. Do you have any witnesses you plan to call?
I do not.
Okay. I guess Mr. Elijah Ellis needs to step outside and show where he can be seated. Central witness.
Your Honor, can I move the court for a bottle of water?
Do you have one, or?
Well, I was told that I had to leave it outside and I threw it in the garbage.
They gave me a bottle of water last time at the motions hearing.
You can go if you need water. There's a water fountain.
I mean, a cup to continue. I'll be talking for quite a bit, so. Okay.
I think what we can do is take a break if we need to get some water, but.
Thank you.
All right.
Deputy Simpkins, could you tell the judge your name, please?
Angie Simpkins.
And you are employed by the Montgomery County Sheriff's Office?
Yes.
And on July the 8th of 2025, were you working as a bailiff in the Montgomery County General District Court?
Yes.
And that is located in Montgomery County, Virginia?
Yes.
And did you have some interaction that day with Elijah Ellis and Joseph Ellis?
I did.
And was that in the courtroom?
It was.
And who was the judge that was presiding that day?
Judge Duncan.
And did Elijah Ellis have a court case that day?
Yes.
And did you, you didn't know him from before that time, is that correct?
That's correct, I did not know.
And then at some point, did you have some contact with Joseph Ellis, who's our defendant today?
I did.
And at some point, did you place handcuffs on Joseph Ellis?
I did.
Was that in the courtroom or outside?
It was in the courtroom.
And is the person that you placed the handcuffs on, is he here today?
He is.
Could you point him out for the judge, please?
He's the defendant to my left.
All right, the record will reflect that the witness has identified the defendant.
At some point, did you learn that an audio recording of the court proceedings had been made?
I did.
And is it your understanding that that was done without the court's permission?
Yes.
Objection. Court permission isn't needed under statutory code 16.3569:2. The party to a case can make an audio recording. It says nothing about
It says it may make a recording, and the traditional way of doing that is to request permission before you do it. You just don't assume. It doesn't say you shall be permitted. It says you.
It says nothing about permitted. So the judge, I didn't call him out on this just because it was irrelevant, but he wants to try to turn it around as that. So I'm going to actually just pull this up real quick since this is being recorded. Let me pull that statute up. I've already showed it here. It says nothing about permission. An audio recording of the proceedings in a district court may be made by a party or his counsel. The only restriction is in juvenile or domestic relations court, which was not the case for this. So anyway, and then no judge of a district court shall order or require a party or his counsel to submit a copy of an audio recording made pursuant to this section or a transcript of such recording to the clerk or district court or to be maintained in such party's individual case, or prohibit a party or counsel from providing such a copy. So basically, the court can't direct me to give the attorney a copy, and they can't prevent me from giving the attorney a copy. And there's nothing about permission. So anyway, Judge, you're wrong.
May, which means that there is conditional, and that means that it
Nothing
is approved
about
by the court.
Whatever.
So, overrule your objection.
Deputy Simpkins, have you had an opportunity to listen to that recording?
I have.
And does it fairly and accurately represent what you heard while you were present in the courtroom on July the 8th of 2025?
Yes.
Judge, I'm going to move for admission of that recording.
Objection on the grounds of hearsay. The audio recording was obtained through YouTube video, so authentication cannot be made. We don't know who uploaded it or if it's ever been edited.
Well, the witness has said that she has seen it correct, and basically all she has to do is verify that it is consistent with what she observed. The source is really not critical.
Well, I object to that on the grounds of authentication and foundation.
What foundation do you want for it?
Judge, I have a witness who was present during the entirety of the audio, what is recorded on the audio. She has listened to it and indicates that it does fairly and accurately represent what she heard while she was present during that time.
And where did the audio come from?
The audio was posted online, I believe, by the defendants, but it was something that was posted online.
Well, I think you can put it on. I guess I can make a decision. I have to listen to something. I can't exclude it without hearing it. So go ahead and let's see what it is that you have.
It may take me just a minute to try to get this sound turned on.
Your Honor.
It makes me wonder where they got information to then go and say, oh, we found it on this YouTube website. Like, that's very weird, bro. Like, how would they know that?
Yeah. I'm not sure. I can only speculate. Real quick, the audio that you see in square brackets is the audio that they're playing that my mic is picking up. So it's distorted. I thought about splicing the real audio in here to make it clear for everybody. That's way too much time. So anyway, that's why you see this in brackets. Now, Cam, back to your point about that. I can only suspect that when Elijah would send emails to the attorney or to the sheriff's office, the custodian of records, and he CC'd the PIITP.com email addresses, that maybe they looked up the website, were like, well, why is he copying these guys on the email, and then saw your website and maybe found it from there. That's the only link I can make on how they did it. Or some little, stool pigeon saw the case number on the video and was like, well, let me go look that up. And because one of the, they see like the filing. And so you could see what court it's in, what.
You talking about a troll?
A troll, yeah. Yeah. And so they might have just tipped them off just by seeing your channel and were like, hey, here's this case number. Thought you might want to know. I don't know. Those are the only two things that, because I'm thinking, how did this come back to them? But it would either be through them checking PIITP.com from who Elijah CC'd in his emails, or that some troll just saw it and was like, hey, just a heads up. I don't know.
Your Honor.
Hey, I see Tanawa's hand is up. Tanawa, you want to say something? You're more than welcome, buddy.
Yeah, so with regard to what you were just saying, they are watching videos, you guys. And so I don't know, to what extent they are, but that was the basis of Jessica's detainment from Homeland Security, was they specifically said that we stated within some video, some live, that threatening remark. It was found to be, unfactual, but nonetheless, they are watching videos. We've got a number of states that are threatening us on practicing law without a license, but yeah, they are watching them, but I don't know to what extent they're watching them. So we're trying to be as cautious as possible within the videos to make sure that we present the most powerful foot. So sorry, guys.
Yeah, no, for sure. Hey, and I appreciate you joining. Thanks, Tanawa. Love your work, man.
I appreciate it. Thank you, brother. It's good to hear your story here. I'm listening.
Yeah, awesome. Yeah.
I don't have to take across the water until the station has been fully established. If you let me make my statement first, please. Yes, Your Honor. If you let me get to that just 1 second. Your Honor, I cannot consent to crossing the bar until our jurisdiction has been fully established. If you be so kind of, Your Honor, I object to that term. This is my private counsel, who will be assisting. He is not aware. He does not speak for me. I'm representing myself as a man, sui juris. If you let me state that I'm here making a special visitation and not making a general appearance, if you let me get into that, please, Your Honor, I greatly appreciate that.
I'm sorry?
Hold your objection.
Okay. Can you mark the timestamp on that, please? Where's that at?
Judge, I can,
Okay. All right, that's fine.
I guess, I suspect there might be more than one time when I would be asked to do that, so I'm not sure how the court would like to do
Continue to
that.
play it so I can hear the.
Judge, I'm going to jump back just 10 seconds so we can start from there.
Here, making a special visitation and not making a general appearance. If you'd let me get into that, please, Your Honor, I greatly appreciate that. Yes, Your Honor. Your Honor, if it pleases you, Your Honor, I will step forward, but let the record show that I'm still challenging jurisdiction. But I will step forward to the podium if it does please the court. Your Honor, Your Honor, Your Honor, it is my Sixth Amendment right to have assistance of counsel with me here today. My Sixth Amendment right, pursuant to the Constitution of the United States of America. What was that, Your Honor? Your Honor, I agree that I invoke all rights. In all due respect, this is a violation of the Sixth Amendment of the Constitution, as well as Section 1, Article 1, Section 8 of the Virginia Constitution. Are you aware of that? Are you?
I don't know. There's no disorder here for contempt to be played. I'm providing assistance to counsel. Are you denying this man's right to counsel? The Fifth Amendment allows or protects the existence of counsel, not of the license, of private license bar card holder, attorney at law. It is private counsel. I am not speaking to the court. I am simply providing assistance to this man who is trying to exercise all of his rights. I am providing assistance of counsel to this man who is exercising all of his rights. The court has provided as this gentleman was the judge, because people aren't allowed to address the court in reality. There is chaos here.
He's making a hyperbolic scenario, because it's not that anybody is speaking from the gallery, and it's not from the gallery, it's at the bar, the threshold of the bar. So crossing it is just a form of consenting to their jurisdiction. Now, obviously, Elijah is putting them on notice that it's being challenged. So crossing the bar, he could have done. But the main reason I believe that Randall wanted Elijah to cross the bar is because once he does that, then there's no way that I would cross, because then they could say, well, you are not allowed to cross our bar here. And I think that's the main reason why he was pushing this so far, because there have been times at court, me, my daughter, my wife, who dealt with other matters where we didn't cross the bar and challenge jurisdiction, and none of the judges had any problem. It wasn't until Randall was here, and then this is also the first time where I was standing by my son's side. So, yeah, Tony, it is a trap. Okay, I'm going to continue.
Your Honor, if it pleases, again, I will absolutely come up to the podium, but I'd like to make it clear for the record that I am still challenging jurisdiction, and I'm not consenting. Okay, but Your Honor, do you understand that I'm only behind here as to not consent to the jurisdiction of this court, but I will absolutely come up there and talk to you and address you respectfully, Your Honor. I'm trying to stand here in peace and honor. I'm not trying to disrespect anyone in this court. I'm just exercising my right and not consenting to the jurisdiction of this court until it has been fully established by a verified claim verified claim supported by oath or affirmation pursuant to the Fourth Amendment. Yes. I'd like to come up to my assistant of counsel. I'm very serious. Sir, I don't want to do this. I don't want to do something. So, when you pull
likely got a seat on the gallery. Yes, I'm sorry. I'm sorry. I'm tired of doing it. I'll do it when it's time to address. Don't interrupt me anymore, okay? Yes, sir. Yes, sir. Thank you, brother. My pleasure. This is what I'm talking about. That's the point. It's over the fact. The point that you believe that you want to do. Again, some will see it in the heart of the reader. You want to, otherwise, the reader will pay for it.
So this judge's Randall's hypothetical scenario is that, he's implying that you have to pay your dues to exercise your right. Basically, they've paid their dues. So I guess if you don't pay your dues, you can't invoke and exercise your right. Anyway, I just want to say that. And then he also, his comment, if the court was so ill-advised. The court is definitely ill-advised.
Well, that's not the case. You're interrupting me. I did not interrupt you. Don't interrupt me. You will answer your question. This court, we know, is an any living and has representation.
Another thing he's doing is conflating assistance of counsel with representation. So, anyway.
You are not wanting to practice law. You were in line for the court at the democracy of the court. So, here's your problem. Let's see what the gentleman is saying for you. But if you interrupt the speaking, you would have the court hold you to that. The court was not going to do that. And I understand what's going on here. You know, like the future that the court had to address earlier this morning. So I'm not surprised based on her side of it. And I'll go ahead and address you already. After the court politely, respectfully, both of you doing, I'll say you give back and smirk and laugh. Well, you don't understand, young lady, the court has the power and authority to hold you together. Great conduct brings us to the court. Maximum punishment. 10 days in jail and $5,200. I don't know why you people have come in here this morning conducting themselves the way that you have. But you're not going to run this forward. So, Miss Edgar, your cuffs on, take the cuffs off of him, let him have a seat, and I'm going to tell you, just like I told her, proceed at your own peril this morning. Yeah? No, you may not have any contact with him while he's standing here to tell you. You may not provide him any advice. If you do so, the court advises very politely, very respectfully, that the court will be compelled to hold you to him.
So, real quick, I'm going to turn the volume up on this video because it's going to be, probably another 15 minutes of hearing the recording from July 8th. And so it's, I'll try to turn it down and catch it, but it might get loud when, if I miss it. So, anyway, just turning it up for you, Mickey.
I don't want to do it, but he forced the court change the court movement. So, give him an opportunity to have a seat. If he wants to do the job, if he doesn't conduct himself like he's doing. Okay. It's okay. It's a set of trials. Officers of the magistrate or arraignment. We are not here today to try
Yes, Your Honor, if I may. Your Honor, if I may, as I stated earlier, that I am here by a special visitation, making a general appearance. Your Honor, we mean no disrespect to this court. We're just trying to uphold the law as the Constitution of the Sixth Amendment of the Constitution does say, in its own words, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. It is not a hearing. However, I am still, I'm here by special visitation and challenging jurisdiction. I understand it's not a hearing. Challenging jurisdiction because there is no probable cause. I've seen no verified. Your Honor, if I may, Your Honor, if I may, I've seen no verified claim supported by oath or affirmation pursuant to the Fourth Amendment for the Constitution for the United States of America. I have not seen such claim. If anyone here has that claim or such claim here today with them, I'd really like to see that. Your Honor, I comprehend why I am here today. Your Honor, I waive no rights. I'm exercising my own right to present myself as a man sui juris. Your Honor, I have not been able to make my full opening statement. I understand that this is just an arraignment. Okay, thank you, but please do not interrupt me when I'm speaking. Yes, sir, Your Honor. He keeps interrupting me. I'm sorry, he's throwing me off.
So all we're here is to ascertain whether you will be retained in the country representing. That's the fourth point of the coming. Away to our campus. What's not going to hear is this other argument. That's for the day of trial, okay? Not for your arraignment. That's the fourth point. What you want to do in regard to the jury. As far as the classical misdemeanor, if you are convicted of maximum punishment of 12 months in jail, and will fine up to $2,500, and under this particular statute, you lose your driver's license up to 6 months. So, what's your pleasure in regard to the case?
Your Honor, as I stated, it is, I don't waive any rights. I will not be having any man represent me, and I will be presenting myself. A man, allegedly. I waive no right. I waive no right. I am exercising my right to present myself, Your Honor. Your Honor, I brought up how I'm challenging jurisdiction, and I still see no verified claim supported by oath or affirmation pursuant to the Fourth Amendment of the United States of America. And since there is no man or woman here to make any claim against me, I have to ask for this court to be dismissed and my private property be returned to me. And until that verified my private property, the private property that was my vehicle. My automobile was taken from me on the night of the 21st after I was arrested with no verified claim supported by oath or affirmation pursuant to the Fourth Amendment of the United States of America. And since there is no man or woman in this room who's making that claim against me, I move to this court to be dismissed, Your Honor. Then Your Honor, have you seen this verified claim supported by oath or affirmation pursuant to the Fourth Amendment of the United States of America? Have you seen it?
I'm trying to tell you, you refuse to look at
Your Honor, I'm standing here in peace and honor. I'm upholding law. I mean no disrespect to you. I'm trying to help you settle this matter. I mean no disrespect, and I'm sorry if I come off that way. I'm trying to be as respectful to you in this court. But
every time.
Yes.
I try to make you interrupt.
I've not been interrupting you. I've been. Well, if you are referring to when you dismissed my private counsel as in accordance to my Sixth Amendment right of the Constitution for the United States of America and the Virginia Constitution, Section 1, Article 8, if you are, okay. I'm letting you speak, Your Honor. I'll let you finish. Okay. Are you finished? All due respect.
All right, read that form.
The waiver of right to representation. I don't waive any right.
You have the Constitution and that belongs to the best of the if you follow, you go to that, therefore, you're going to represent. You won't do that, the Constitution will let you up to the you won't find it. If you don't correct,
I will be presenting myself. Like I stated with my notice of rebuttal for the consent that I did file, Your Honor, I will be presenting myself, not representing myself. Your Honor,
yes or no?
Respectfully, Your Honor, I'm not waiving any rights. I'm not waiving any of my rights, but Your Honor, I'm trying to say that I will be presenting myself and I will not be having anyone represented for me.
You're refusing to sign this form,
the form of the right. I do not sign any form that waives any of my rights. Your Honor, all due respect, I just stated that I will be presenting myself and I will not waive any of my rights. Any signature that has been written for me has been done under duress, and I do not consent to anything that you're doing for me. I will not be hiring an attorney. I will be presenting myself. Yes, Your Honor. No, Your Honor. Your Honor, I'd just like to state that I'm not trying to delay this proceeding by any means. I'm not trying to delay anything. I'm simply asking if you have seen that verified claim supported by open affirmation pursuant to the Fourth Amendment of the United States of America. And if you have not seen such claim, then we can go from there.
Your copy of the waiver form and a copy of the waiver form. I see you smirking with me, and you smirk on the phone, but you don't come back and go to that. If you all make them respect the our system, then sure, I don't care about me, it's not about me, it's about our system stuff. Particularly me, young lady, I didn't fairly know. Last night, we did this one, obviously, of course, not going to hesitate to find it. Having said that, you know, I'm very proud. But I hope you all will conduct yourself appropriately when you come back to the trial on the school. All right?
Thank you, Your Honor. All right, I just meaning no disrespect. Thank you, Your Honor.
All right,
So that was just renew my motion.
So that was the audio. They're going to play it again. I'll skip through it the second time around. I know the audio wasn't very clear because my microphone, my recording device, was trying to pick it up that was being played on the TV that was at the courtroom. All right, so now we're going to get back to my trial.
For admission of that at this point in time. I think there was previously some objection to sort of the chain of it. There's no requirement that a chain be completely unbroken. I think Your Honor certainly has experience enough in having been present in general district courts to have been able to listen to it and determine that it seems to be a fair and accurate representation of what might happen in a courtroom, and that is what Deputy Simpkins told you that she heard, and it did reflect what was going on in the courtroom that day.
Deputy, you've listened to that previous?
Yes, sir.
What you heard on the, I guess the tape or whatever there was a accurate detail of what occurred at court that day?
Yeah, what I heard. The writing maybe that went with it wasn't always exact, but what I heard was.
All right. I will admit it, but I think that there are statements that are made by Elijah Elias, which may be hearsay. And I realize Commonwealth may not be trying to use it for truthfulness of what was said, but that it technically is hearsay. if there's any question about admissibility, it may not be admissible, but this does go to show the context of what was going on. Statements made by the defendant, on the other hand, are statements against interest and can be considered by the court. Do you have any other questions?
No other questions for the deputy, Your Honor.
All right. Commissioner Wise, if you have questions for the witness, now it's time to ask those questions.
I do. It's still unclear what the Commonwealth is alleging. I do have questions for the deputy here.
I think that's what you need to do.
Okay. All right. All right. Can I sit and ask questions?
Yeah.
All right. How long have you been a deputy?
A deputy probably 9 years, but law enforcement longer.
And how long have you had the assignment, bailiff?
About approximately 14 months.
And has that been with Montgomery County General District Court?
Yes.
Entire time? Where exactly were you positioned during the relevant events that allegedly occurred on July 8th?
Initially it started in front and then ended up behind you and Elijah Ellis.
Did you have body-worn camera that day?
No.
Did you write any report, supplemental email, or note about what you observed on July 8th?
Wrote a document to my sergeant and lieutenant.
Can you describe what that document consisted of regarding the events?
The document just explains my version of what occurred in that hearing that day.
How many pages would that document be?
I think it was a page and maybe a half, approximately.
Did Tyler Morgan contact you about this case on or about August 11th?
I don't remember the actual date he contacted me, but he did get in touch with me.
Okay. He showed you a photograph and you said this person, quote, looked like him except he was bald now?
I can't remember what I said. I do know he showed me a photo.
All right. Did you provide Morgan any sworn statement or affidavit about the events on July 8th? Was your conversation with Morgan recorded?
Not on my end.
Did you personally hear the accused state he was licensed or authorized or a lawyer?
Repeat that, please.
Did you personally hear the accused state that he was licensed, authorized, or a lawyer?
No. No, there's not those words.
Okay. Did you personally hear any statement from the accused denying he was a lawyer or denying that he spoke for another?
I heard him saying that he was not licensed, something to those effect, not exact words. He was just providing assistance of counsel. That was the constant phrase.
Okay. Did you hear the accused state that he was not addressing the court?
I don't recall
Do we need to replay the video?
Maybe because that was a long one. I don't recall exactly every word that was said that day.
Does the court recognize when the alleged accused stated he was not
We
addressing the
may
court?
have to replay part of it. But go ahead with your questions.
Can you identify the specific person the accused allegedly represented to another that he was authorized to practice law?
No.
Can you quote the exact words of the accused used that you claim communicated he was licensed or otherwise authorized?
Judge, I'm going to object to that. I don't know that Deputy Simpkins has made any claims about that. If he's just...
Well, I think he can ask if she recalls. I mean, we have the tape that we have to replay, but if she has personal recollection, she can say she does.
Can you repeat that question, please?
Do you recall the accused, can you quote the exact words the accused used that you claim have communicated he was licensed or otherwise authorized?
I don't claim anything, but I have no quotes for any conversation.
Okay. If you can't quote any exact words, can you describe the specific conduct that you claim is communicated as authorized, or explain what conduct conveyed authorization rather than general discussion or private assistance?
Objection, Your Honor. Again, this is really going towards the argument part of it. The deputy is here to describe, factual things that she recalls, that she heard or saw, and that's, he's asking her to apply those, and then how would that go to this charge?
I'll withdraw the question. Did you hear the accused state that he was not licensed attorney at law?
I don't recall hearing those exact words.
So you did not personally hear any statement or observe any conduct that communicated authorization, or cannot testify to the element of first-hand knowledge?
I can testify that I don't know the exact words, that he kept saying he was just providing assistance of counsel. I can't testify to exact words that he used to imply or inform the court that he was not an actual lawyer, because I don't recall the exact words.
Okay. Is assistance of counsel the same as practice of law?
Objection, Your Honor.
I'll sustain the objection. I think that's for the court to determine.
Okay. Did you take any notes on July 8th?
I did not take any notes.
I'm sorry?
I did not take any notes.
Okay.
I wrote a note to the sergeant that day.
And the lieutenant?
Yes.
Okay. Do you recall what that note consisted of to the sergeant and the lieutenant?
As I said before, it was a description of, from my version, from my peace of mind, or my place in the court, of what occurred that day.
Do you have that with you today?
I do not.
Was that sent by email, or how was that delivered? Was it printed and hand delivered?
Yes, I believe I just printed and hand delivered it, but
Okay.
I can't be positive on that. I can't recall that exactly.
Okay. Is that document saved on your computer?
Yes.
And has that been provided to the Commonwealth?
I do not know that. I did not give it to them.
All right. When was the first time you refreshed your recollection about July 8th? When you first reviewed the video or discussed it with Morgan or the Commonwealth? Do you recall the first time that you reviewed these?
The first time I reviewed anything that happened that day was most likely when I heard about the recording online. And I listened to that.
Do you know when that date was?
I do not know the date.
Do you have a rough estimate when that might have been?
I do not know. It's been a little bit of time. I do not have an estimate.
And about how many times have we discussed the events that happened, that originally happened on July 8th with the Commonwealth or investigators? About how many discussions between you all?
Maybe twice, maybe. Not, that's not exact. Probably, I don't know. I'm thinking maybe twice.
All right. And when were those discussions? When did they take place?
With an investigator, that was probably a few months ago, and with the Commonwealth attorney, the only discussion I had was about being in court, and that's been a while. That like being subpoenaed for court, and that was back a few months ago.
That would have been after you spoke with Morgan?
Yes, I think so.
Did anyone tell you what they believe the legal significance of the accused statements before you testified for practice of law or unauthorized practice of law?
No.
Okay. So your identification observations, the appearance and names used do not by themselves prove any, quote, holding out as authorized to practice law. Is that correct?
Objection, Judge. That would be a
legal question or legal answer with the witness is a factual witness. Sustain the objection.
Okay. So you cannot identify any specific person Joseph told you was authorized or to practice law in Virginia. Is that correct?
That's correct.
Okay. So unable to identify anyone who is authorized to practice law as you told anyone.
Unable to identify anyone that is able to practice law?
Yeah. Let me rephrase
no,
that.
I can't.
Are you able to identify anyone that that the accused has represented to another that he's authorized to practice law?
No.
Okay. Can you quote any statement by the accused claiming he was a lawyer, licensed, or authorized?
No.
Did you witness the accused receive any compensation or anything being offered in exchange for any advice or representation?
No.
Did you witness the accused drafting or filing any pleadings or legal documentations for another?
No.
Did you witness the accused entering an appearance or speaking on behalf of another as their lawyer of record?
Not as a lawyer of record.
Thank you. No further questions, Your Honor.
Redirect.
Deputy Simpkins, we've listened to the audio, but what the audio doesn't tell us is what kind of physical interactions there may have been between the defendant today, Joseph Ellis, and Elijah Ellis. Can you explain to the judge what, if any, kind of interactions you saw where Joseph Ellis was speaking with or indicating anything to Elijah Ellis during that proceeding?
Okay. That occurred back behind that little bar, what we'll call it, behind the bench. I was standing behind Joseph and Elijah Ellis, and when Elijah Ellis would, at times, try to speak to the court, Mr. Ellis would be whispered in his ear. It happened several times. And sometimes when the judge would ask questions, that's what would happen.
And when that happened, was Elijah Ellis speaking, or was he quiet and listening to what was being whispered to him?
Objection irrelevant.
Overall objection to the answer question.
At times it was both. There were times he was speaking and he would, Mr. Joseph Ellis would lean over and whisper while he was speaking, and there were times that he was not speaking. Joseph would whisper in Elijah's ear.
And this all took place behind the bar in the gallery part of the courtroom?
Correct, on the left side.
But that was during the time when Elijah Ellis was speaking with Judge Duncan, or Judge Duncan was speaking with Elijah Ellis?
Yes.
And was there also some sort of a large book or binder that you observed?
Yes.
Who had that? I
actually saw that both of them at some point had a book or binder with tabs on them.
And what did Joseph Ellis seem to be doing with that, with regard to that, if anything?
It appeared as though when a question was asked from the judge that at times there would be a flip to a certain tab to read in the book.
And who was doing the flipping to the tab?
Joseph Ellis.
Objection irrelevant.
I think it is relevant over your objection.
No redirection.
All right. Let's replay the tape this time. I'd like to look at it again.
I'm going to fast forward through the next video.
Listen to it again.
They're going to go through it again. And forward with that. And it's a crappy audio of that.
Your Honor, do you want to start from the beginning and go all the way through? Or I do have, I know at about 3:29 is when the defendant, I believe is when the defendant first starts.
You can start there. That's fine.
This is a violation of the.
I don't care about me, it's not about me, it's about our citizens' job. Particularly when they don't do everyone. You act like you just break.
All right. Now we're getting back to trial.
Kathy, just one additional question for me. What did the defendant do? One point in the tape here, Judge Duncan says you have an option, either take a seat or you be held in contempt. And told him to proceed at his own peril. What happened then?
After I took the handcuffs off and Judge Duncan said that to him, he did proceed to go to the right side of the gallery and have a seat on a bench.
And at any time after that, was he in close proximity with his son?
No, sir.
Okay. All right. Does someone have any additional evidence?
Judge, I'll call Elijah Ellis.
Raise your right hand and be sworn. Swear firm, tell the truth, the whole truth, and nothing but the truth. Yes. Please have a seat. We'll need to answer questions from the Commonwealth Attorney and also from Mr. Ellis if you have a question. Go ahead.
And Chapel Judge, your name, please.
Elijah Ellis.
And how old are you?
22.
And what is your relationship to Joseph Ellis?
I'm his son.
And you had a reckless driving charge here in Montgomery County, is that correct?
Yes.
And is that case still going on in circuit court?
It is. It is under control.
And your court date for the arraignment in general district court was July the 8th. That's correct?
I believe so.
And on that day, did you have a licensed attorney with you?
No, I did not.
And are you an attorney?
No.
And your father, Joseph Ellis, attended that hearing with you, did he not?
He was there with me.
And you referred to him as your private counsel, is that right?
That's right.
And that is a right that you asserted under the Sixth Amendment of the U.S. Constitution, is that correct? And what does that mean, you private counsel?
Private counsel, my understanding of it was someone to basically come with me and just basically be by my side for the date of the arraignment. Just help pretty much calm my nerves.
Now, you told the court that your dad was going to be assisting you, is that correct?
Yes.
And how was he assisting you?
Flip through my pages if I need to. You know, that's, I mean, pretty much, I really just wanted him by my side.
And when you say flip through your pages, you had kind of a large binder or notebook type thing.
Yeah.
And what was that?
Information that was pertaining to my case, like things I filed.
And when your dad helped you flipping through the pages, was he was helping you to find things that would be helpful to you at that point of what was going on in court?
He would have, but he didn't make it that far.
But that was part of what you had hoped he was going to be able to do, was to assist you in getting to section.
Have things set out for me.
No money, baby.
You prepared them.
Dollars on my motherfucking service, baby. Tell you like dollars.
Did your dad help you with that?
With like getting like labels and stuff for it, like I had tabs for each pages, but I put in each what's it called, folder into the binder myself, so I knew where things were. But you know, when you're up in court, you can stumble a little bit.
So it sounds like your dad knew where things were too, since you were hoping he could help you to find things.
Yeah, I mean, there's tabs on it. So there's.
And you filed a number of different written motions in your reckless driving case. Is that correct?
Yes.
And you signed all of those and submitted them to the court yourself, correct?
Yes.
How did you know to do that?
I mean, the information out there is free. ChatGPT, YouTube, it's pretty much just knowledge.
Did your dad look those over for you as well before you submitted those?
Yeah, help me like if there's any spelling errors and codes, I might have put the wrong codes down. He'd show me, you know, if there's any errors, but I had the final say over any of them.
And on your arraignment date on July 8th, your dad was not permitted to come up
past the bar.
Is that correct?
That is correct.
And when you did not want to pass the bar, is that also correct?
That is correct.
And when you were back in the gallery part of things, your dad was able to communicate with you some at that point in time. Is that right?
Do you mean before the court?
No, I mean when you were addressing the judge and the judge was addressing you, your father did some speaking to you at that point in time.
I guess when we were both standing up there, I'm sure maybe.
All right, I don't have any other questions, John.
Questions for the witness?
Yes. Did you, were you represented by anyone?
No, but I present for myself.
So you were representing yourself?
Yeah.
Your legal matter?
Yeah, well, I like the term present.
Present yourself, okay. Nobody was speaking for you, though?
Yes.
Okay. Has anybody represented to you that they were authorized to practice law in the state of Virginia?
No.
Okay. Has anybody prepared pleadings and or instruments for hire and exchange and compensation?
No.
For you? Okay. Let's see. A couple more. All right. And you filed a notice on July 2nd. This is entered into the notice of dismissal that the accused filed on October 8th. It was provided to the Commonwealth and the court has it in its docket. Do you recall a notice of private assistance of counsel and affirmation of exclusive voice?
Yes.
Is this your wedding signature on here? Would the court like to see this?
Yes, that is my wedding signature.
And you have a copy of that as well in the notice of dismissal. And that's also in the case file. So this reads, I retain and act under my greater and endowed unalienable right to receive private assistance of counsel of my choosing. Is that correct?
Yes.
I do not consent to representation. Any man or woman assisting me in private counsel shall not be acting as an attorney nor speaking for me, but rather offering assistance in honor.
Mm-hmm.
Okay. And that was filed July 2nd?
July 2nd.
And for the record, how much do you owe your father?
A lot.
Okay, thank you very much. No further questions.
No other questions, John?
This witness subject to recall?
No, sir.
You plan to call him?
Elijah again? No, I did not.
Right, you stay in the courtroom then?
In the courtroom?
Commonwealth rest, John.
Commonwealth rest. Michelle?
So is it the Commonwealth's alleging that the accused represented Elijah Ellis?
I'm not sure I understand what you're asking.
Well, I'm asking, I'm still trying to find out what exactly it is that the Commonwealth is alleging other than unlicensed practice of law.
What's the Commonwealth's theory?
Yes, that's
finally,
right.
finally gets to the freaking question I've been asking for months.
Well, Judge, are we at the argument point of things, or is there going to be testimony from the defense at this point in time?
The accused will not be testifying.
I want to kind of get a grasp on what the Commonwealth's treated as if he made a motion to strike.
Now, I don't know what he's talking about, a motion to strike. I'm not sure what he's referring to, treated as he made a motion to strike. I've been asking for the theory that the Commonwealth has been alleging for practice of law since the very beginning, and now, you know, we're at trial and the judge is finally asking the Commonwealth what the theory is. So, yay. But as far as he mentions treat it as though he made a motion to strike. I'm not sure what he's referring to that. So I don't know. Anybody on the call know what he might be talking about? Somebody with a little bit more courtroom experience? Are you guys unable to unmute? I don't know.
Genoa, Jessica, anything?
Sorry, guys. Hold on, I gotta turn off our Bluetooth here. There you go. They want to talk to you about that.
Okay. Hey.
All right. So Tanoa, the judge said, let me just rewind it a little bit back here.
Thank you. Appreciate it.
I'm sorry, are you saying something? It's a little.
No, I'm so sorry. We're driving, so.
Gotcha. Okay.
Yeah, you'll hear some background.
Okay, so the judge says treat it as though he made a motion to strike. He's referring to me. I don't know what he's talking about. So I'm just going to play this audio real quick. Try to listen close. If I need to turn it up, I think I can do that. So the background is the Commonwealth is asking, are we moving to arguments already? And so finally, the judge says, well, what is the theory that the Commonwealth is alleging for practice of law? And this is what I've been asking for months, from the very beginning. So now he's finally asking that. And then the judge makes a statement that says, treat it as if he made a motion to strike. I'm not sure what he's referring to. So I'm going to play that audio real quick if you can listen, and maybe you could share what you think he might be referring to.
At this point in time.
You choose when I'll be testifying.
I want to kind of get a grasp on what the Commonwealth's treated as if he made a motion to strike. He didn't.
Yeah, so I don't know what there would be to strike.
Isn't it the complaint?
Oh, I see. So made a motion to strike the complaint. Man,
right.
Okay. So that's specific language, because I've been asking. I see. So maybe I should have done that from the very beginning, rather than ask for the specific essential elements to the charges that they're alleging.
Well,
Okay.
I mean that's what I got from the first deputy's testimony was that there was no complaint. She didn't hear you practice. She didn't hear you claim to practice, and then you asked for the accusation, and the state was unclear as to whether there was anything to argue. There's nothing to arbitrate.
Yeah.
Okay. And the judge said, assume that he had a motion to strike. But I would assume that you would have to ask the court for that and motion the court for it. But the judge did that for you.
Yeah. So he gets points for that. But that's good to know. Okay. Because I didn't make a motion to strike for that. I've just been asking, hey, if you're going to allege this violation, this statutory code violation, at least list the essential elements that actually qualify what that is.
Right.
But
I wouldn't say that was good on the judge. I would say that the judge was directing the prosecutor in a very specific direction.
Yeah. Okay.
Yeah.
Okay. All right. I'm gonna continue. I appreciate that. Thank you.
Okay. Just treat it that way. What would the Commonwealth's response be?
So the Commonwealth's response to that would be that there's a U.S. Supreme Court case. It's Wheat versus U.S., which says, it's Justice Rehnquist, and he says, well, regardless of the persuasive powers, an advocate who's not a member of the bar may not represent clients other than himself in court. And so really that's the gist of things here with unauthorized practice. Do we have someone who has come, and I certainly understand we have a father-son relationship, and as parents we know that we would like to help our children. The problem I think here is, did he leave his son thinking that he had private assistance of counsel, his dad, to offer him legal assistance in things. And I think the answer to that is yes. And that's exactly why we have unauthorized practice on laws, is because we don't want the litigant before the courts, the defendant in a criminal case in this situation, to think, well, I love my dad. I trust his counsel, and he's telling me to do this or that or the other thing. I don't doubt that, his father, the defendant today, loves his son. The problem is he's not a licensed attorney, and therefore he might be giving poor advice to his son. It is not simply enough. So specific things that I think the Commonwealth sees that were done that create a problem. It is not enough for a non-lawyer to just say, "Oh, well, I don't represent him. He's honest, that he's not a lawyer, but I'm here as private counsel." Well, what does that mean? That means that what he wanted to be able to do was to come forward and whisper things to his son while he's addressing the court, to assist by flipping open to sections of the binder and pointing out things that were there. And the Commonwealth also knows that there have been a number of things filed in the cases. So that's additional, things where it certainly, I think, has happened where Joseph Ellis is assisting his son throughout this. And his son constantly refers to his Sixth Amendment right, which we know is to counsel, and refers to, his father as private counsel. The defendant refers to himself as, "I'm providing assistance of counsel to this man." He says, "My pleasure is to provide assistance of counsel. I'm not practicing law. I'm perfecting law. I'm providing private assistance to him. I'm not speaking to the court. I'm only providing guidance and assistance to him." And those are exactly the traditional things that an attorney might do, Judge, to provide counsel, because in Virginia we're attorneys and counselors at law, so providing counsel to our client. So that is the Commonwealth's theory, that it is not, we're not asserting that Joseph Ellis came and said, "I'm an attorney," and we know that he's not, or that he received compensation for representation of someone. But what he did was interacted with his son in the fashion that an attorney would, and intended, and did in fact come here.
That's her opinion. That's her opinion, obviously, because it's I didn't interact with my son as an attorney would. I interacted with my son as a father providing guidance and counsel would.
Thank you.
So anyway, all right, I'm going to continue.
Yeah, that's their perception.
Yeah.
Counsel, I'm here to assist him, and I am here to perfect the law. And all of those things are suggesting that the relationship between the two was one that you would see from an attorney. Now, I'm going to jump ahead a little bit, Judge. The Commonwealth is not, we're not seeking some sort of jail time. In fact, we're not even seeking, honestly, a conviction in this. We do want the behavior not to occur again, and would be happy with some sort of deferred disposition. There are still cases involving his son in front, of courts in this locality, and we do not want to have this situation occur again. So that's the Commonwealth's purpose in this, is to make sure there's some understanding that the behavior would be criminal in action, and we don't want to have a continuation of it.
No.
Well, I'll just be very candid in looking at what is before us at this juncture. And I understand there's things that happened outside the courtroom, but in the courtroom, kind of put it in a nutshell, Mr. Ellis came forward with his son and basically interrupted proceedings.
No, I didn't. Now, for the record, I did not engage. I didn't initiate any discussion. You guys can hear from the audio. It wasn't until the judge asked who was standing next to Elijah. He asked Elijah, who's this standing next to you? And then he engaged me with questions to who I was and what I was doing and if I'm licensed and all that stuff. And I told him I'm not addressing the court. So I didn't interrupt any proceedings. If he wants to make it sound like my presence is there is interrupting, standing quietly, then that's just, a perversion of reality. He's making it more than what it is. I didn't interrupt it. The judge made an issue out of it. Randall did. And I didn't initiate anything.
Because of, I'm going to call it a mistaken, misguided, and egregiously absurd interpretation of the Sixth Amendment.
Which, again, this is his opinion, and he's going to say this is my opinion. Which he's, obviously we're not going to agree. I'm not going to agree with him. But the conversion of our right into one of licensure is what's egregious and absurd. And for them to think that, they want to conflate assistance of counsel with representation. And you hear the language, you hear Randall going back and forth with that, and you don't hear so much with this judge. But it's they conflate what assistance of counsel is, trying to overlay that it's representation, and that's not the case. All right.
The argument that it doesn't, there's no prohibition against assistance of private counsel. There's just, there's nothing that says that you have to be licensed, so you can be, if you're, you can be a private counsel under the Sixth Amendment, and that's just not the case. I guess when all this stuff was done, when our people that founded this country were drafting a lot of this, you probably didn't have to have a license to be a doctor.
Another hyperbolic scenario. Oh, you need a license to operate, to practice medicine and everything else. And again, it's whatever. I'm not gonna. Let's finish this.
At some point in time, you needed a license to practice law. You needed a license to practice medicine. And it's done to protect society. You don't want somebody operating on somebody that doesn't know what they're doing just because they say they're a doctor.
And okay, real quick, since it's my body, I own my body and my rights. If I want to get medical advice or, seek some nutritionist or whatever, and they're not licensed, but I'm going to take that, their advice, that's on me. Okay. I'm not going to require, anyway, this whole licensure, the conversion of our right into license is just atrocious. And, you should have every right to do what you want with your body, even get medical advice or assistance from somebody else. Now, obviously, it's wise. You want to make sure that they're well educated, knowledgeable in that field, but to make it a requirement, they're just trying to link you into that commercial nexus. All right, I'll continue.
And at the same time, you don't want somebody, representing somebody in court that hadn't been through training that you need to have, the right to do that. And the state regulates all that. So this whole thing about the Constitution saying, it's okay to have private counsel, just garbage.
That's his opinion. And
a lot of that was played back and forth. But I get down to what Judge Duncan got to the bottom line is, this has gone on long enough. I've tried to explain this to you. You can't do this if you don't have a license to practice law. Mr. Ellis may disagree with that, and his view is entirely wrong. But Judge Duncan said, either take a seat or I'm going to hold you in contempt. And I think that's, pretty much he was getting pretty close to being held in contempt. And he told him to proceed at his own peril. He went back and he sat down. So I don't think he really crossed, the line at that point. Yes, he did interrupt court. He did delay court. And
No, they're conflating a couple things. Now, I knew at this point in time that I could interject and talk about, and correct the judge, but I felt that he was already moving towards dismissal, and I was just going to let him continue. I wasn't going to call him out that, his opinion of my and Elijah's view of the Sixth Amendment is egregious, absurd, and garbage. I think that's a mistake on his part, but I didn't feel the need to call him out on there because I felt like the conversation was already leaning towards dismissal, which you'll see in the next couple minutes.
And all that, and I think the judge could have held him in contempt. But he didn't do that. He was basically trying to be accommodating as he could. So I don't find that what happened in court reached the line or threshold that you need to be practicing law. I didn't. If he'd come forward in front of the bench and started representing him or represented that he was licensed to practice, I think it'd be different.
And that's the key linchpin right there. Represented as licensed to practice law, and that was never the case. Even if I persisted at Elijah's hearing, and they did find me in contempt, and everything else, that they would still be in the wrong because that's not practice of law. So, the next person could put that to the test. But that's where my stance is that everybody has the right to assistance of counsel. Now, obviously not representation. You have to be well knowledgeable and capable of handling your own matters. You handle your matters and you seek the counsel, as the Bible says, seek the guidance and counsel of those, so that you're not going into it alone. So the counsel is wise to have. There's nothing by any means that it has to be by licensed attorneys at law to represent you. That is a distortion and a perversion of the Sixth Amendment, of your right to assistance of counsel. Maybe that's just my opinion, but I feel like that's obviously not this court's opinion. It's not Randall's. It's not this judge's or the attorney's. But I think that, the fact that our rights predate any form of government, the Sixth Amendment predates the establishment of the American Bar Association, which I think was like 1838 or something. We don't need license for our rights. All right. Let me continue.
That didn't happen. I think everybody knew who they were and everything. There's just this misunderstanding. What I said is just completely false just without any basis that you can privately counsel somebody without being licensed as far as the Sixth Amendment goes. What happened outside of court, all these documents that are put together here. The son has testified he did it, whether dad, the defendant, helped or not. The crazy thing is we're in a different world with this chat GPT. I've learned to use it myself here lately. The kids have my wife said something about it. I've played with it myself, and you can come up with all kinds of legal briefs and stuff like that. You don't even have to have a law degree, and you can file stuff, and it might sound like it makes sense. Maybe some of it's garbage, but it does. When you look at it in print, it sounds like it's okay. Maybe the son did that, like we said. He found those type of things. I don't know to what extent the father assisted him. But at the same time, there's a little bit of leeway I have to give a parent. I know myself, my son goes to college and he has to enter into a lease. He brings the lease home to dad to look at it. And we all do those things. And I don't think anybody would accuse me or anybody else, any other father or mother, looking over a lease to help a child out, because it is a legal document. I don't think we'd be accused of practicing law without a license to do that. So I think whatever assistance that was done, it was more or less as a parent. And I don't know that it went further than that. Um, so, do you understand what the Commonwealth is saying? That they're really not interested in it. Well, I don't say not interested, but they're not seeking to get a conviction here. They're not asking for jail time or anything like that, but they just want to make the point that you just can't be saying that you're representing somebody and coming to court like you did.
I never said I was representing them.
You said you were private counsel.
Right, providing
Okay,
assistance
and that
counsel.
is not.
Providing
I mean,
assistance counsel.
you're splitting a hair that doesn't need to be split. It can't be split. And you know, you can sit here and argue with me all day long, and you're not going to change my opinion on that. So they're just you've been advised, you've been put on notice.
Okay, real quick.
Judge
So
Duncan,
he
one of the
says,
things,
I just caught that when I was going through this video. I've been advised and I've been put on notice. I don't know what he's talking about, what notice I've been put on. And I don't know if anybody else picked that up, what that might be. But anyway, I'll
To the regards of your UPL. Verbal notice of what could happen and what might what will happen if you continue.
Your treatment was the notice.
What's that, Zach?
No, I was just saying your treatment was the notice.
Yeah, that's true. Yeah, I've been put on notice that if I ruffle feathers, they're gonna arrest half my family.
And that's how they're gonna get down. That's the notice.
Yeah, I think what they were really saying was, well, Joe, we don't want other people to know that you can do that, and we don't want that to get out because then other people would be able to smash these cases too. So we're just going to arrest you. We're not going to, charge you with anything, right? We just needed to get you out of there for that particular proceeding because there was people in there and we didn't want them to hear. So you were put on notice, bro.
Yeah, I think that's it. But anyway, all right, let me finish this. We only got a couple minutes, couple seconds.
I noticed he said there'd be a fair trial. You know, to an extent, some of the behavior here has been very aggravating, but at the end of the day, people, when they come to court, I believe, get a fair trial. And I'm being fair when I say that I've listened to the case and I've listened to the evidence, and I want to dismiss this. So you're free to go.
Thank you very much.
Will that be dismissed with prejudice or without prejudice?
With prejudice.
You can't bring up the UPL again. Is that correct? With prejudice? Can't bring it up again? What's the difference?
They can't bring. I mean, they might charge me with another UPL later down the road if I do something similar to this. But this particular matter, for what occurred, what allegedly occurred on July 8th, can't be brought back up.
Yeah, I believe if it's dismissed without prejudice,
they can bring it back up later.
Right. I think they have, every state's different or whatever, but I think they have 6 months. If it's dismissed without prejudice, then they have 6 months to bring it back up and refile it. But if it's dismissed with prejudice, means they can't bring it up. They can't bring it back up at all. It's over. Done.
Right. Yeah. Hey, Troy, let's stop the recording and then, I guess we can go on, but Cam was asking to stop it.
Can I stop it? It looks like I might have ownership. Let me see if I can work that out.
Okay. All right. So that was my trial. Yeah, it was a trying time. There was a lot of uncertainty because, who knows how far they were going to go. When I did go to trial, I had an appeal and stay of execution ready to go because you don't know what these guys are going to do. And so, that would have put a stay on any sentencing. But I think that what really did it was, while they didn't act on any of my filings, I think that they recognized my standing. If I did take it to a court of record or, even a higher court, state or U.S. Supreme Court, that they would have just been shot down right away because, again, they want to conflate the license of our right into one of practicing law. And it's an abomination to who we are as well, sure, as Americans, but just as mankind in general, where let's eliminate all of that, the ordinances, the codes, the statutes. You take it down to the bare inherent rights established and given to us by our Creator. These are our Creator endowed rights, our unalienable rights that can't be taken away from us, while government, what mankind creates, tries to do it. It just can't. It can't be done. But you have to know what your rights are. You have to stand on them and hold firm to them, because again, it's the Creator created hierarchy. The Creator is always greater than the created, and mankind creates government. Mankind is greater than government. God creates mankind. God is over mankind, and so there's a hierarchy that is delegated to each of us on each layer. So God has delegated us our rights. We need to stand up. We need to know what they are, exercise them. And then, we created government. Government has delegated certain things to do, but it's limited. It's not a delegation that overturns what its created does. There never can mankind ever become over our Creator.
And that goes down the chain too. Once you get to government, there's levels of
absolutely.
And also, they got a file that they flipped upside down, and now the local police think they are more powerful than the freaking Constitution, or the city or local county governments, or county officials are the worst.
Yeah. Oh, absolutely. So, anyway, that's my story. That's
Shut the recording off though. I don't know. I don't have access.
Oh yeah. Let's see. I don't know if I can. I'm the co-host. If you
let me
can.
do anything with the little red button up top. So.
All right, Cam's gonna have to put his data on hold and come on back.
Whole thing.
Oh, here we go. I see. Record to this computer, record to cloud. Oh, I can't. I guess we can't do it.
Yeah, that's all I could do too.
I'll message him. Maybe he'll stop by the house or something.
The state arbitrarily and erroneously converted my right to assistance of counsel into a privilege by charging a license and a fee for it. That's unconstitutional, Your Honor. Since the state did convert my right to assistance of counsel into a privilege and charging a license and fee for it, I can ignore the license and the fee and continue with assistance of counsel with impunity.
Yeah, exactly. No, Doug, you're going straight to like American jurisprudence, man. You got that down packed.
Carl Miller. Get some. I can put that his filing in the chat, I think.
Discord? In the Discord?
Oh, that's oh, I gotta pull it up now because he got me on the spot. That's Shuttlesworth versus Birmingham, Alabama.
Which one?
And
oh, that's probably 1963. I used that one in yeah, that's what that one is. I used
Murdoch
that one.
Pennsylvania.
Did that work for you?
No, I haven't. Oh, Joe. Okay,
yeah. I've used it. So so here's how, when I mentioned that one. So Shuttlesworth v. Birmingham of 1963 is that now this one was actually the city of Birmingham was requiring people to get a license to protest, basically, and that is against the First Amendment for the right of redress against your of grievances. And so Shuttlesworth was a pastor who did not get a permit and exercised his right to redress his grievances. And then it ended up going to the Supreme Court, and the Supreme Court ruled that he did not have to get a permit to exercise his First Amendment right. And so that's where that comes from. So it's specifically about requiring a permit to exercise any rights. This one was about protesting, but it applies generally. You have a right, and if you have a right, you don't need a permit or a license, and that's what they're trying to apply here, is that you need to get a license to get representation. Sure, representation, yes. Assistance of counsel, no.
Because he's being paid.
Could that also apply because I'm from Florida. I've never had a driver's license in Florida, but
Yeah.
I've had one when I was maybe 25 in New York. But I've never signed a contract here in Florida, and they keep hemming me up with that.
Yeah. Is this Willie?
Yes.
Yeah, Willie.
Yeah. Yeah, Willie. So again, they're obviously going to make presumptions and assumptions that you're engaged in commerce. Now, the motor vehicle code is all about the definitions of what driver, operator, motor vehicle is. These are all commercial terms when you're engaged in commerce. So Troy has really been compiling a whole bunch of information about the motor vehicle code that we really need to compile it all into like an expansive document so that we can just
found another good one I just stuck in the chat.
yeah.
PDF. If you go to the PDF for the transportation code, there's all kinds of shit in there that they never publish online.
Yeah, no, and they're not
Of
going
course they wouldn't.
It says
They don't want you to know they're fraud.
So Willie, my point is that getting a license to travel, they're obviously going to try to. You see it on the video. You see the videos Cam posts and puts where they're trying to convert. They're trying to say that you're operating a motor vehicle and therefore need a license and blah blah blah.
Right.
You have to rebut that. You're going to be met with resistance on the side of the road and at court, and you just got to make sure that your record is perfected so that when you finally do get into a lawful court of record, that you can show, hey, these are the presumptions these guys are making. These are my rebuttals to it. They've ignored all of my notices asking for to answer my affirmative defenses. They've ignored it. So they haven't provided any verified claim or evidence of wedding signature that subjects me to this commercial code that they're claiming.
Right.
So you just got to perfect your record and have that ready to support your standing.
Now, Hillsborough County is a court of records, ain't